Let the matter be listed for admission next week, madam.
Next week.
Yes, madam.
All right.
When
When do you want?
23? Monday. Wednesday then?
Wednesday or Friday?
Yes, madam.
Wednesday.
My pleasure. With regard to item number 20, madam, if the representation filed by the government, madam, that has not been taken, madam. Can it be called for, madam?
Next week.
Next week.
Item number
20, madam.
20. 20. Where is the council on the other side?
Madam, I am calling for the affidavit. Just to take the record.
No. All right. It is submitted by the learned counsel for the
Samuel Muslim is there and Amit Goel.
petitioner. The respondent that an affidavit has been filed by the government. And therefore, but we listed on. Very
25th, madam. I'll inform them.
That's what I beg to make for the and have it in March. Which year? 25. 25. So you have it in 27. 9th of March. 9th of March. Monday.
First, I beg to mention item number 1, madam. Madam, some kingdom is madam.
6. Yes.
Madam, I beg to mention item number 1, madam. I am getting on behalf of respondent, madam. Madam, the matter may be come up after 3 weeks, madam. The documents I have received from the department is illegible, madam. So I.
Who's for the petitioner? Any objection?
I am for the petition. And inquiry for and matter may come up after the case.
When you get it? Here in February.
After 3 weeks, madam. 3 weeks time.
Matter be listed on after 3 weeks, listed on 16th of March. Interim order, if any, passed early. 16 March.
May I say, Your Lordship, I beg to mention item number 49 for admission matter.
49.
Yes.
Yes.
With due consent, Your Lordship, I have taken consent from the petitioner. That matter will come in the first week of March.
Item 49, it's made by MSK Pugan appearing for
Huh?
AGC. Stands referred to be listed on 16th of March. Submitted with the consent of counsel to the petitioner.
Date, please, my lord. Prayer for listing of a motion matter for Friday, my lord. One more prayer, my lord. Prayer for motion matter as per your lordship.
16th March.
16 March.
I recommend item number 46 on behalf of the Pegu Madam. Kindly matter may be adjourned for the day next.
Prayer is made on behalf of Mr. Counsel CGC.
Yes, madam.
Have you informed the petitioner?
Yes, madam.
Counsel for the petitioner is next week, or let it come in March. 6th of March. 6th of March.
May I please, Lord? I am praying for listing a motion matter today, my lord.
When?
Sir, the petition matter has been selected in 2023, my lord, and appeal was filed. Appeal dismissed, my lord. On technical point, my lord, this selection has been now set aside.
Not today. When did you file it?
Yesterday, my lord.
Some Friday or Monday?
Friday, my lord.
Friday. Subject to clearance of defects.
I beg to mention a prayer for listing for motion matter, my lord. Friday. I like to make sign number 17 or with the concern of the other side. There are some talks of settlement still going on.
Item 17 on the request made by the counsel for the respondent.
Yes, sir.
Submitted that the parties are attempting to solve the matter. Why don't you go for mediation?
It's an arbitration material also.
You can go for mediation. Parties are ready. Go down. This time is so good. They're giving you 3 weeks. If it doesn't work out, then pass the week. Second after 3 weeks.
Lordship, I pray for listening for fresh motion matter on Monday, Lordship. And another prayer, Lordship, in admission for them.
Admission will be on 16 March.
Lordship of
Yes.
Lordship, I'd like to mention for listing of admission matter, my lord, on Friday, my lord.
Not Friday.
My lord,
March.
the matter is relating to the year 2021. My lord.
Whatever, 16th of March.
I am deeply aware.
Retreat, Your Lordship. I beg to mention item number 11, prayer for Passover.
Item 11 stands passed over.
Matter may be
On the
listed
request-
after one.
On the request made on behalf of the petitioner. Matter be listed after 1 week on a date.
Okay.
I'd like to mention item number 29.
29.
Lordship, I am appearing for respondent number 2 to 5. Lordship, affidavit is ready. We will be filing within 10 days.
Item
My lord.
29, counsel for respondents.
My lord, I am
The
for the
affidavit is
petitioner, my
ready.
lord.
Shall file within
10 days.
10 days.
My lord, identical there was made on last working day.
Why are you
My lord,
agreeing to
My lord, I am not objecting, my lord. My
No,
lord,
no,
fix
then
a
why are
date.
why are you agreeing to this prayer? We'll take up when the matter is called up. Either you agree or you
Fix a
disagree.
date, my lord.
Huh?
Fix a date.
We'll fix date in all matters. It's matter after 2 weeks. On a date to be fixed by the registry. Council for petitioner. The registry will fix a date. He'll come on a fixed date. Want a fixed date? March. 20 March. 0.
Please, my lord. I have a prayer regarding 2 WPC for listing
Or
uh,
admission.
admission. Go to what?
Admission. 20 March.
Applies. Yes, Your Lord. But we have prayed for this. But for Lord. Friday.
Friday.
Possible Lordship on 25th.
25th. Here.
25th, Lordship. This is regarding selection and appointment of flag mandala. We're supposed to list on 19th of January, Lordship.
Let it be on March. 9 March.
2nd March, Lordship. 2nd of March.
9 March. No. 9 March. 9 March.
Sure, Lordship. Lordship, I beg to mention item number 40 on Lordship. Kindly, we need 2 weeks time for filing the additional affidavit.
Why don't you take use of these adjournment slip for these matters? You want 2 weeks, 3 weeks? Get the adjournment slip, submit it to the court master. Instead of making a mention, picking up court time. But adjournment, get a consent from the other side, circulate the mentions.
We have tried to communicate it with the case voicemail, but not done, Lord.
Not done, then we can't adjourn it. Get his consent.
Right.
You try, keep trying or wait until the matter is called up. Which item?
Item 40 on Lordship.
41.
Lordship, we have received instruction as well as the inquiry report, Lordship.
You are for whose part? Who are you?
I am for the petitioner. Then, Lordship, 2 week time may be given. Lordship, we will file the additional affidavit, Lordship.
What are you challenging here?
Yeah, Lordship, it's a matter of compensation, Lordship, railway matter. We have received
You
instruction as
inform
well,
Mr. Google.
but Lordship, I have no contact number as
You
well.
get it from his colleagues. Go to the CGSE office and find it. Yeah, are you not from Gauhati?
Yes, Lordship.
You're from Gauhati. Yes or no?
Yes, Lordship.
Yes, you're familiar with the premises of Gauhati High Court. There is an office of DGI, Deputy Solicitor General's office. Go there, get his number.
Okay, Lordship. Thank you.
No, you go and get his permission. What kind of a mention are you making? Can't find his number, you can't inform him. What is this? Go and get his adjournment. Sponsor.
Therefore, listing two matter matter. Listing to promotional matter.
Which year?
This was 25 matter.
16. 16 March.
Lordship, item number 33, I'm representing half CDCR daily. Having some medical emergency.
Have you informed the other side?
Yes,
Item 33 on the request made on behalf of NLRDV. See?
One.
It's after 1 week list on 9th of March. Council for petition.
I beg to mention for listing one WPC of 22 Lordship. Kindly matter may be listed for admission
On 16th March.
Lordship, I beg to mention for listing for admission.
But back to mention for listing a matter for admission, Lordship.
16 March.
Oblige, your Lordship.
The restriction is delivered into the appropriate forum. The US applied for the post of Gauhati and
Expected by the spread under the instructions that were intended. The model will very stand with you. I've heard for the state.
may I please instead of the word dismiss also
Closed on withdrawal.
Inspector page 9.
Direction.
Direction of the page 18.
Respondent. Files post. So 1 week from today, may be listed after the return delivery.
it's 17 for order.
17.
31 is the
1-7.
no, yes, 17 and 31 is the relevant. Thereafter.
31. Counsel for participation notice returnable for steps on responded by speed post in 1 week. Stop returnable date. Where is the order? Where is the direction in the order?
Order is the page 20. There are 25. There are 20.
I heard counsel for participation notice returnable for stop the returnable date.
Here, petitioner challenge the order dated the annexion 9, page 51. Earlier, the order was for regularization, and read, madam. Compliance of the Honorable High Court order dated 1/11/2021 passed in the presently working as casual labor temporary status under non-police status. It as per with regular MPF with effect from earlier, while he was in service, he was terminated. Then matter was there was a reference to the industrial tribunal. Industrial tribunal was held there. Lordship will kindly operative part at page 30, madam. In the light of my above discussion, I hold that at the time of termination, the workman has attained the status of temporary workman and his termination by management without any reason or without following procedure established by law is not justified, and workman is entitled to reinstatement and regularization. According to this reference, is answered in favor of the workman with the direction to the management to reinstate the workman in a regular vacancy. Thereafter, the management has given temporary status to him, and they are challenging that again the repetition was filed after passing order. Temporary status was given to him, but he was never regularized. Then he approached this honorable court, and honorable court. Lordship will find that page 48. Page 48 is the standing counsel is an undertaking. At page 50 is the relief and part. I read the first. It appears that on 21/2/2008, the petitioner was granted temporary status. However, the other part of the award dated 12/2/2002 passed by the Landed Industrial Tribunal Gauhati was not implemented. Folder so and so submit the management. Third paragraph. So and so Landed Standing Council Brahmaputra Board fairly submits that since the board was undergoing various restructuring policy, there has been some delay in implementing the award dated 12/2/2002. However, it is not a case that the award has been completely ignored, and part of the same have already been complied with, as would be reflected by the record of the case, including conferment of temporary status. Landed Council further submits that as per instructions, the process is on, and within an outer limit of 4 weeks from today, the award would be complied with fully. After hearing the parties and taking into consideration the submission has fairly considered regarding implementation of the award in question, the present institution is disposed of by granting further time of 4 weeks to fully comply.
Now, what do you want?
Prayer, my lord, my service was not regularized into letter and spirit, as per this in terms of this order.
Then you should have filed.
I have been treated.
You did not file contempt.
No, the contempt, my lord, we have not filed because, my lord, rightly or wrongly, an order has been passed. So, my lord, after this order, they have treated me at par with the regular MPS. And now, my lord, I am not entitled for the MSCP, my lord. I am not entitled for the LC. I am entitled only for 50% of the gratuity. So at least let the notice go, my lord.
But there is already an order.
Yes.
There is an award. Then another is order. And people issuing orders like that, you should have filed a contempt. Mr. Roy,
Earlier, there is the order.
there is an order to implement the award.
Lordship.
But that has not been done. Why have you not implemented the order? The award.
That Lordship has to take the instruction.
Get your instructions. Time of your termination, you were working as what?
Casual level.
Then you were terminated.
Yes.
Then
Then matter was, the reference was made.
the court directed that you should be reinstated.
Reinstated and regularized.
No, reinstated in a regular vacancy.
Yes. And I am entitled for.
There is no direction for regularization.
Yes, I am entitled for reinstatement and regularization.
Where is that direction?
Page 30. Madam.
Page 30.
Yes.
Yes.
Last paragraph.
Reinstate the workman.
Reinstatement. Workman is entitled to reinstatement and regularization.
Page 30.
Yes, ma'am. Last paragraph.
Page 30 is the continuation. 29 last paragraph.
Actually, it was kept as defective. Thereafter, type copy was annex, perhaps that is there or not.
Not true. It's here, but type copy of which award?
Type copy of the this award dated 12/2/2022.
22.
2002.
2002.
Yes.
So the original award does not say so, which is available.
Original award says, logical kindly come to
page 22 it begins.
yes, 29H, 29H.
29, yes.
Yes. In the light of above discussion, I hold that at the last paragraph, at the time of termination, the workman has attained the status of temporary workman, and his termination by the management without any reason or without involving procedure established by law is not justified, and workman is entitled to reinstatement and regularization.
This has not been appealed against. No reason.
So,
but you were not a regular employee at that point in time.
no, I was casual, and thereafter temporary status was given.
Get instruction, Mr.
Okay.
Rohit. Or you want us to issue notice?
Okay.
See, is probable. Extra copies be served in the state court.
Consequently, this matter will be taken at two lots.
Alright. Why the delay again?
My lord, the delay, my lord, I have explained in para 222. My lord, because my lord, the petitioner approached repeatedly and also filed representation.
That will not
My
absorb.
lord, in last occasion, my lord, delay was right, but it was rejected by the time this was happened. They needed to pay the full pension, my lord, but they failed to pay, my lord. There are 8, my lord, they raised this question, my lord, there are 8. They occur.
Okay, but
The aspect of delay, we have been unsuccessful, but the lordship permits will file an affidavit on the point of delay.
Last time also filed it. And your lordship judgment is well not there.
Returnable goods. So you're representing the PNRD. Correspondence number 1, 2, 3, 4.
6.
1, 2, 3, 4, and 6.
6.
And MS 7. And Ms. M. Bhattacharya for respondent 5. Therefore, respondents are represented.
PN7 is appearing.
The pendency of this petition may not be part.
Yes.
Item number 10 is sufficient.
Item 10.
Same.
Similar.
Similar.
Same one. Together.
But the fairly avalanche.
Okay, because the petitioner applies for the post of constable matter, and thereafter he passed all the segments thereafter after perusal of the facilities and the petition regarding subsequently the petitioner compared with the cutoff mark and in cutoff mark obtained by the petitioner is the
When you get instructions here,
Yes, sir. We know that.
you have your instructions.
No, lordship instruction. He has produced a PWS certificate issued after the last date of the online application, lordship.
Get your instruction.
Yes, lordship. Notice have to go, lordship.
You will have to go hard counsel for party.
All respond.
9 for lordship.
8. 1 to 8. Then Bhattacharya.
appointment of the on 24th.
Already select list published, lordship.
Let them start.
Already
That
list.
way, every expedition comes, you'll have to keep one post vacant. Ultimately, they'll not be able to go in appointment with all the other candidates also. How many posts are there?
Various categories,
We're seeking appointment in which post?
Constable.
I prefer all the posts. And
Then
as
you can't
per my,
keep- where do you want us to keep one post vacant?
in as my BSF, CISF, and CRPF,
One
I am-
post.
of the
You tell us. You have to tell us. You can't keep one post vacant in all the services.
any one of the
You tell
combined
us,
examination.
tell us which service you want the post.
Got high mark, then the
Right, get the instructions. You not be able to tell us. Service.
I am eligible at present in the CRPF, CISF, and BSF.
Which one do you want?
Any any
It is not left to us. Tell us what.
CRPF, then CRPF.
Petitioner consider.
Already published,
The
lordship.
basis of the select list.
time will be required, Lordship. Select list published by SSC. Different departments,
The respondents may proceed for filling out. Constable. Constable.
may I please, Lordship?
Shall
Whether,
not be filled up till the next.
whether posts are vacant or not, if
We
yes,
don't know, we said one.
then,
Subject to availability of vacant.
yes, Lordship, that.
Right.
Alright.
File with the
You are challenging the office memorandum. Nine
Lordship,
24. See for.
Lordship, yes, I am appearing, but Lordship, in this matter, kindly consider the date of death, Lordship. And the challenge is, Lordship,
Challenging the OM.
OM Lordship, but this has not been, Lordship and already passed an order not entertaining this petition,
So
Lordship.
you give us the notice.
I shall provide the number, Lordship. After some time, I shall provide the number.
After some time.
matter pertains to regulation of service lordship. We are all casual workers in forest department, my lord.
Yes.
More than 32 years we are working, my lord. Our for regulation they denied, my lord. Paragraph, my lord, kindly see paragraph 10, my lord. To clarify the situation, my lord. Paragraph 10. May I read lordship?
You are still in service.
Yes, still we are working. Still.
In Borola.
Yes, BTC.
BTC. Yeah.
May I read lordship? The respondent authority, more particularly Deputy Secretary Dr. Assam, Finance so and so department, addressing to the Secretary Dr. Assam, was initiated process for regulation of petitioner. And in this regard, records were examined and found that the petitioner did not cover by the scheme proposed by Government Assam so and so. Petitioner did not fulfill the stipulated conditions of government for regulation of their service, as the petitioners were not engaged against any vacant post. Since then, all the petitioners are working as casual of more than 32 years of continuous service till date in the forest department under the various forest division, Borolan Territorial Council, Kokrasar. And all the petitioners were placed under the fixed pay, and subsequently in the year 2017, petitioners pay minimum scale of revised with date pay and also receiving DA, increment, etc. as per the state government norms. It is pertinent to mention herein that the fact that this increment, DNS allowance, DA, house rent, etc. are integral and mandatory components of salary for the permanent government employees, and eligibility of DA so and so are standard for permanent top employees. And as such, the petitioner entitled for regulation who are working for more than 32 years of continuous service in the forest department under various divisions. The petitioner further begs to state that the duties discharged by the petitioners under various forest divisions are perennial in nature because their core responsibilities are essentially involved continuous long-term management, conservation and protection of forest ecosystems and their associated services. And the petitioner's tasks are essential for environmental stability and ecological balance, which are ongoing needs and responsibilities done by petitioners are not one-time project, but are integral to the ongoing well-being and management of natural resources, making the nature of the working continuous and permanent. In fact, that the duties of forestmen are perennial in nature.
Are there similarly situated persons like you who have been regularized?
My lord, yes, my lord, some are.
Where are your appointment?
My appointment at my annexer, kindly see the annexer 2, my lord. Paragraph, my lord. Para 7.
So kindly see para 7, my lord. We have not annexed the entire, but these, my lord, documents. If required, my lord, I am able to produce all the same, my lord.
So, right, just annexure to page 64 is one such document.
Yes, my lord. Para 7, I have stated. Now, their jobs, my lord, done by the petitioners on preliminary nature, my lord. Now, Supreme Court says, my lord, on that issue, my lord.
What?
That is, my lord, para 11, kindly see, my lord.
Of para 11 of your petition.
Yes, my lord. Correct. Case 51, relevant portion, my lord. Supreme Court ruled that if the work performed by the employee was essential, continuous, and of nature that regular employees will properly perform, courts are more likely to order regular even if the sanction force was not initially available. And in instance case, petitioner's case was rejected for regulation as they were not engaged against any sanction vacant post. But the recent ruling of Supreme Court has clarified that if the duties are paid in nature and to continue extracting such works for decades while pleading want of sanction strength is the position that cannot be sustained, and also clarified that Umarbi judgment cannot be served as seal, justify expectative engagement persisting for years. If duties performed are essential, continuous, and of a nature that regular employees topically perform, court are more likely to order regulation even if sanction force was not initially available. But right now, there are available vacant posts available. Para 9, minor. We have already indicated how many posts are available.
Yes, we can see what you need.
At this stage, my lord, I'll be
Surveillance is what?
Casual offers.
Under the respect to various forest divisions.
BTC Kopraja.
CA. Services for camping. Tomato. State should be. Necessary posts.
five and six.
4, 5, and 6. Mr. Nayak, please. For what? For one. Mr.
B does.
B does
One
for
and
1 and 3. Mr. Nayak for. This one. File necessary affidavit. Yes.
My lord, a set of employees of the Inland Water Transport Directorate, my lord, going on. My lord, by earlier round of litigations, the incorporation of the directorate to a company was challenged. My lord, your lordships held that there being no legislation, you cannot do it this way. That was quashed. Gone back. They come up with a similar notification. That being challenged, my lord, something was shown to the court that there was an agreement of the employees. My lord, your lordships were pleased to close the petition, giving us liberty that if you are aggrieved, you can come again. That being so, but my lord, we go back and see that what has been shown to the court is a agenda, and my lord, the persons are present in the meeting. Agenda of that meeting signed by our representative. No minutes were drawn, not to speak of any assent being given to the my lord minutes. My lord, I'll not invite your lordship to that controversy right now. What happens? Matter standing as it is, that you cannot transship, transport, or vest government property to a corporation or company without a suitable legislation. The lordship follow the Balco case. The matter stands as it is. There is no legislation. They have not yet come out one with it. Again, by virtue of a cabinet memo, they now pass series of orders, my lord, by vesting lock, stock, and barrel, everything to the company. My lord, subsequent orders are under challenge. This morning I come to know by a separate petition by means of the petition of a separate set of employees, not my legislation. But my lord, the parent cabinet memo is not under challenge, which is under challenge before your lordships.
In this proceeding.
In this proceeding, my lord, page 105 is the cabinet memo. This is not under challenge, this is my instance. But the subsequent orders which I have challenged here are under challenge there also. My lord, lordship, please keep a very small page 105 bottom. This proposal 6 approval of the attachment of DWT employees to AIWCL. My lord, AIWCL is that company, corporation of which was under challenge, your lordship held. You cannot do it without a registration. My lord, kindly come to page 114. My lord, where it pricks me. 114. 5, my lord. These are the proposals. To approve in principle for redeploying the employees of DWT to AWCL and so on attachment basis as placed in the so and so. My lord, I don't know where do I stand. I'm an employee covered under 309 proviso and 311. My lord, the moment I'm thrown to a company, 311 totally goes away from me. Not only that, my lord, the lordships have again and again held that a public servant once covered by statutory norms, you cannot change his service condition without, my lord, either taking into consideration tripartite negotiation or, my lord, framing new set of rules where you show that his service conditions remain as it is. If you don't know, my lord, it doesn't remain as it is. These are matters of factual metrics which your lordships may examine on a future date. My lord, today I stand with a prima facie case before you. That, my lord, in the absence of a legislation, is cabinet memorandum and all its subsequent actions, which are, my lord, page 119 is the ultimate approval of the cabinet. My lord, all other subsequent notifications, transferring all the assets to the new company is a non-est in the eyes of law. My lord, what falls from there, whether I lose, I gain, the matters of factual metrics. I'm not inviting your lordship's precious moment for this today. My lord, the incorporation itself being under challenge, my lord, it is under challenge again, because in 2022, they repeated a similar thing, which is again under challenge from this law. Pending. My lord, till date, they have not shown any piece of paper to show that there is a registration. They have not even gone up on appeal also against the initial order. Initial order is at page 81. They have not gone up, my lord, page 81. Your lordship's first order. They have not gone up on appeal. My lord, lordship may kindly come to page 82, paragraph 2. All the writ petitions, my lord, lordship, all the 3 writ petitions are taken up for disposal to the issued 2007. And the 2 persons filed. State Inland Water Transport Sanstha was initially filed by the same petitions challenging notification so and so, whereby the decision of the state cabinet dated so and so for incorporation of the company under the administrative control of transport department, the name and style of Assam Inland Water so and so as a state public sector under the Companies Act was notified. My lord, lordship may kindly jump to page 92 for your lordship's decision. The 2 other notifications are, my lord, notifying the headquarter and notifying the office. My lord, page 92 are your lordship.
This judgment is not under appeal.
No, this is my lord. This is not under challenge. My lord, this stands. Subsequently, there is another notification which is also under challenge. They have not yet come up either with an appellate order or a legislation, my lord, to validate their action. And my lord, now the 3rd set of actions, these cabinet. My lord, one more thing. Can you see the permanent government employees are thrown to a company with 5 years budget? What happens thereafter? Tomorrow I come to court, my lord, challenging my status. The lawsuit would legitimately ask me, my lord, why did I sleep so long? Page 109, my lord, financial liability. The budget allocation for DWT upcoming 5 years so and so on the basis of approved budget 2025 may be considered as granting aid to this new company, the formation of which is, my lord, not on the cloud, decided illegal by your lawsuits. They are allocating state budget to that company and transferring me lock, stock and barrel there. My lord, lordship may see page 122 for a moment, my lord, Annexure 14, part of those series of, my lord, orders subsequent to the cabinet memo, whereby they vest all fixed and floating assets to that company. How dare they do it, my lord? Page 122. There are other orders. My lord, they change the nomenclature of the posts. They do everything, the new company. Yes. My lord, my humble prayer is, there is another petition, although the cabinet memo is not under challenge there, but my lord, identical, may not be similar. Losses may place both of them together for consideration in future. And in the meantime, my lord, with the prima facie case that this incorporation is illegal, nothing can shift to them, my lord, status quo as of today, my lord. So that my members are not said to draw their salary tomorrow from the company. Once that is done,
Show us the power which, according to the process of,
my lord,
show us
my lord,
under which provisions, which legislation, respondents ought to have proceeded if they are desirous of handing over the department.
my lord, therefore says, if government assets are to be delivered to a my lord, entity apart from government, it may be a state entity also. My lord, this being public asset, a legislation, my lord, a legislation is a must. Mere executive decision of the cabinet is not sufficient. My lord, what legislation they bring is on them. If they bring it, my lord, your lordships may on a given date be invited to check the veracity of the decision or not. But my lord, standing at page 92 as of date, my lord, where are lordships?
Where do you trace the powers from the Constitution? Which article?
My lord, 300. Everything, my lord, 299, 300. All the assets are with the, my lord, they have to enter into. My lord, the executive power of the government, your lordship will find at 154. The executive power does not involve, my lord, transfer of assets of the government. My lord, probably the constitution framers also did not, my lord, visualize the day when the executive of a state, the cabinet, will start transferring public assets to a non-state entity. My lord, non-state in terms of not Article 12, but in terms of, my lord, the state as a sovereign body. Even the constitution framers also probably did not visualize this day, my lord. But, my lord, they have to, when they are doing this executive act, it is for them to satisfy your lordship, my lord, that this cabinet memo can be passed under the rules of executive business.
Well, before the court challenging it.
My lord,
saying that
I am
they are not
challenging
authorized
because,
to do it.
my lord, lordships have already held. My lord, I am here to indicate the stand of law as enunciated by your lordships in page 92, my lord. Under the facts and circumstances of the case and upon due consideration, I find merit in the petition, state respondents having not come up with any legislation, the impugn notification dated so and so, lordships have seen. This notification is the incorporation and handing over, is found to be unsustainable. And it's not an, my lord, it's an inter party order. It's an inter party order. My lord, lordships have delivered it to government.
Yes.
Except this judgment is of 27th of February 2020, page 81. So, lot of water has flown in the river Brahmaputra after that. A new legislation called Indian Vessels Act 2021, which was notified on August 12, 2021, the central legislation. And in the central legislation, lordship, section 5, administrative provision 5, subsection 3 says, the state governments by notification appoint one or more designated authorities within their respective jurisdiction for purpose of exercising or discharging the power, authorities and duties conferred by and under this act and the rules framed thereunder. So the central legislation has empowered us, the state government, to make as many numbers of other authorities under its jurisdiction. The state government by notification appoint one or more designated authorities. So this is a designated
How is designated authority defined? Yeah.
Yes, lordship, I'll definitely make my whole submission. Designated authority is, let me find it out. Designated authorities means the authorities appointed by state government under subsection 3 of section 5. So this corporation is a designated authority appointed by the state government. Let them for challenge this 5.3. Because so far as legislative incompetence, which he is urging, it is not tenable in view of this central legislation. So this argument will not hold.
You have a copy of this act?
Yes, I'll just hand it over, lordship. My friend has.
I knew this argument was taken before.
How can it be taken before, lordship?
It is
After this act came in 2020 when an argument had taken place in 2020.
and thereafter 3 read petitions were filed.
Those read petitions
And
are on a
considered-
different platform,
and-
different subject matter. Subject matters are totally different.
It's like
And
a-
this another thing, another argument that
this is
salary.
like a seasoned player on a
I know.
cricket game where you're
The
there on
other
the
thing
pitch,
is that-
you know what balls are going to come.
Right, Lord. We have to, and he is more seasoned than me. And after Tripura,
And,
he is more seasoned now.
and we can all see the seasoning coming out.
This also, Lord. I wish I get some of the wisdom. But we are missing him for last 4 or 5 years. I'm very happy he's here. At the very beginning, I said, I'm happy to have you on the.
I'm okay.
So now,
Just
Lordship, the
find out.
other point is regarding the salary part. The DDO of the employees were, if in case they are shifted to the corporation, the DD.
But we are yet to be addressed on the legislation. part.
Yes.
How can state property be vested? to
Yes,
a
property
corporation
can be vested.
under,
I
under
argue-
this
I-
act. Under this act.
For
And
that,
what is
we
the-
have to go to Rule 9 and 10 of the Assam Rules of Executive Business 1968 and amendments thereof. And that has precisely been done here. So let me file an affidavit detailing all these factual aspects which my learned friend is raising to an affidavit, because the other identical case was fixed on 11th of March. On the interim period also notice was issued. So if that be the case, I would like to file a detailed affidavit regarding the property. The government has taken the right decision in terms of the Assam Rules of Executive Business, Rule 9 and Rule 10.
I agree to this. Only one, Madam. Meanwhile, status quo.
No, I seriously object.
Madam,
Because Lordship has passed the
how
same
can status
for
quo-
judicial discipline, this cannot be done.
My lord, status quo, because tomorrow they come and tell that what has been done cannot be undone. What has been done cannot be undone. In an interim category, I am on the trouble, my lord. Yes, maybe after final hearing, you have to set aside everything and serve long enough. But my lord,
Lordship can always turn back the clock.
We have issued notice.
The difference is one is a union, other one is a association. That is the only difference.
sets of employees,
Except the lawyer only.
sets of employees are also different.
Status quo in that
My lord, my service condition.
service condition.
Service condition.
Not a single service condition is going to be touched.
My lord,
No tinkering.
let that be recorded. Let that be recorded.
No, it may not be recorded now. It may not be recorded because this is a part of the cabinet memorandum. What is there in the cabinet memorandum and what has been approved duly,
No.
it's a part of the record.
Still, this is the- Still,
DJ copy.
so, states. Association, state. Association.
It is
7/12/2025 cabinet memorandum date.
7/12/2020
Yes.
and required.
119.
Its functions and functionaries of the transfer. What is company?
My lord, Assam, my lord, with response number 3 and 4 before your lordship. Assam Indian Water Transport Corporation or company.
Company limited.
Limited.
Assam Inland Water Company Limited,
Company limited.
namely responding.
4 and 5.
Here. Serving under the Directorate of across different cadres in India. Here, employees. Service rules. Respect. Service rules applicable to them. Earlier, transfer the assets and liabilities into so and so company, which came to be SAE, spoken by the same union. By
No,
the same,
no, my lord, the other petition by different union.
by different.
Yes, earlier same union.
Huh?
Earlier same union. There are
By
three
the same-
petitions. One of
same
us.
petition. by the associations or staff. Say taken. Allow the action. Submitted by the senior counsel, that's penalization of spot number 5 company restructuring. Function. Eight companies. Petitioners are agreed that by virtue of this covenant are bound to be altered. For and proceeding with the cabinet memorandum. Circumstances the right challenging the sale of association already pending before the court. It's in number so and so. And Mr. D. Saikia, Advocate General, State, strongly objects to the submissions. Submits that there is a central act which is framed, which is by the Ministry of Shipping Waterway. Then Vessels Act 2021, whereby there is a provision for identifying designated authority. And it is under such circumstances that the cabinet has taken decision in terms of the section.
Five three, section 5.
So it is your submission that no separate state legislation.
Absolutely.
Therefore, no separate state. As the actions. Proceeded Same act. Central act.
One more regarding their apprehension that their service condition will be changed. Proceed will kindly come to page 106, which is a part of the cabinet memorandum, proposal number 411, page 106. May I read this?
Attachment.
Attachment of eligible DIWT staff to AIWCL and AIWTRA in view of the unbundling of DIWT and the need to modernize the inland water transport system. It is proposed to carry out a comprehensive manpower rationalization exercise by relocating eligible DIWT staff to AIWCL and AIWTRA to attachment. A part of the cadre will be transferred to AIWTRA to facilitate critical regulatory, enforcement and safety oversight functions. The employees to be drawn from DIWT shall be engaged without affecting their existing and future service conditions and without requiring the express consent of the employees in the interest of public service, and their salaries and wages will be drawn from the DIWT's budget during their period of service. So DDO is also remaining the same, the director. So everything is taken well care of. There is to have no apprehension that their service condition will be tinkered with. All. This is state government company, Lord. It's nothing different. Tag with the other one.
Issue.
Highly obliged.
Our interim PR,
Therefore, we are issuing notice.
interim PR.
On interim. Turnable on the same.
Deeply
Deeply obliged.
Now you should go and file an appeal. There is an appellate provision, isn't it? File an appeal. File it before the appellate tribunal.
I'm not saying for
You are suspended.
suspended and later reinstated. Lord. Now, after reinstation, the client is provided with the regular salary.
Okay. Get instructions, Mr.
Lordship.
Urwa. Please to be issued.
Please. Airport.
Mr. Doctor, you have 1 and 2.
One and
Since the respondent is the representative.
Actually, the petitioner, my lord, was appointed as a junior inspector. And subsequently, my lord, he was promoted to the post of assistant registrar of cooperative societies. During this course of service, my lord, on 3/12/2024, he was arrested in connection with ACP case number 93 of 2024. And thereafter, my lord, he was placed on suspension, which my lord will find at page 40, my lord.
This is a good case for an appeal.
It's for, my lord.
Departmental appeal.
It's a suspension case.
That's right. You can file an appeal under the rules. Ventilating your grievances. Sorry, this is cooperation.
Cooperation.
But you were suspended under discipline and appeal.
Discipline appeal. Page
So
40.
there is a provision for an appeal.
Page 40, my lord, they've suspended. Mechanically, they have, my lord, they've extended my suspension. It's more than a year now. And I'm going to retire, my lord.
See rule 14.
Rule 14. 14, my lord, government servant may appeal. In fact, I've submitted multiple representations and nothing has been done with regard to them.
No, appeal has to be before the authority prescribed. Before whom did you submit the representation?
My lord, Honorable Secretary to the Government of Assam. Multiple representations, my lord. Page 79.
Yes, who's for the state respondent? Or you are appearing for all the corporations?
Department, yes, Your Lordship.
The entire department?
Yes, Your Lordship.
Well, please file the representation treated to the appeal under Rule 14 and pass appropriate order. Why is the department sitting over there?
I'll obtain instruction regarding this, Your Lordship.
Please do. There is already a circular that every 3 months they will have to submit
Lordship.
the status of inquiries being undertaken, why the suspension is extended. All these are to be done.
Next time, Your Lordship, I'll obtain instruction regarding.
Heard counsel for parties, petitioner is agreed that suspension
Since, my lord, 22/12/2024, my
22/12. No departmental proceeding has been initiated.
show cause notice has been issued, my lord. Show cause notice.
So cause notice. File your reply.
I filed my reply.
Then inquiry officer,
And they have not appointed anybody.
reply has been filed, however. Subsequent orders have been passed by the state. Either suspension by the state. File with the department of decision has there are provisions of 1964 to see that right. File. File decided by the respective council for the state. It's after it's 2nd of March.
Of next year.
let respondent counsel complete her
Public
notices are not issued, extra copy can issue within
or instruction. It will come in motion.
motion.
Motion. Obliged.
Obliged.
DB obliged.
It is in your interest that
My lord,
you
I
supply
understand.
extra copy.
I'll give.
Right.
Yes.
My lord, this case has some actual background. Basically, the petitioner was working as a lord, cluster head in the LICIS 1. My lord, by an order dated 24/4/25, he was transferred to Kolkata, and the reason for transfer was non-performance. Non-performance. Then, my lord, we challenged this order in WPC number 2366 of 25. However, my lord, there were some problems were there. This writ petition was withdrawn on 19/6/25 with liberty. Then, my lord, we filed the subsequent writ petition, that is 3513 of 25, against the transfer order dated 24/4/25. My lord, on some advice, this writ petition was withdrawn on 27/6/25 without liberty. I think I must point out because my learned friend would be very keen to point out that. Then what he did, my lord, he approached the labor court, invoking section A33 and all. Because, my lord, in Gauhati, he was a cluster head, and he was transferred in the capacity of a credit manager. So actually, the credit manager reports to cluster head. Downgrading. It's a demotion. So, change of condition of service. Then, my lord, the labor court, we approached on 18/6/25, and on 19/6/25, labor court granted an injunction. Now, then, my lord, LIC filed one application before the labor court, which was registered as miss case number 3 of 25. However, on 29/7/25, London Labour Court rejected the miss case of the LIC. Then agreed, my lord, they filed writ petition 4693 of 25, which was allowed by a judgment dated 29/1/26, where liberty was given to us, my lord, to approach the civil court. Now, my lord, question is, once, my lord, that order of 24/4/24 was stayed by the labor court on 19/6/25, what they did, my lord, they modified the original transfer order dated 24/4/25. What they did, they brought me back to Gauhati as a credit manager from Kolkata.
What has happened to the proceeding?
No, my lord, now because of there is a judgment dated 25. One second, my lord. This writ petition of the LIC has been allowed, where it has been held that I am not a workman, therefore I cannot invoke section 2A of the Industrial Disputes Act. Page 55. Now, my lord, most important part is, in modification of order dated 24/4/25, on 25/6 that order was passed. This 25/6/25 order was not a part of challenge in 3513. Therefore, my lord, even if no liberty was granted, there is no problem. Because lordship knows, normally on the same cause of action, liberty is not granted.
What did you challenge before the labor court?
24/4/25.
By which you were
I was transferred from Gauhati to Kolkata
as clustered
as credit manager.
credit manager.
It's a demotion. Then, my lord, eventually what happened, I approached the tribal court, labor court, after withdrawing the litigation before this honorable court. Labor court granted an injunction on 19/6/25.
Then subsequently,
Subsequently, they filed an application for vacation before the labor court. Labor court rejected. Then they approached this honorable court. LIC approaching 4693 of 20. Which writ petition has been allowed, which have annexed in the writ petition, my lord.
where liberty has been given to us to approach the civil court. That order lordships will get at page 65. Please come to page 64, my lord.
The directions in para 16.
Yes.
Then what are you challenging here?
Now, in the present proceeding, no, liberty has been given to us. If your lordship would kindly come to Roman 4. In Chaudhary Lanet so submitted petition enjoying certain interim direction and a cushion period of 10 days be provided to the petitioner so that the petitioner can approach the competent civil court. Taking into account that the petitioner has been enjoying certain interim protection, this court observes that status quo as on today shall be maintained for a period of 10 days from today, that is till so and so. This court further observed that so, my lord, while allowing the repetition of LIC, because the lord proceeding before the labor code is not maintainable, because it is not an industrial dispute and the petitioner is not a workman, therefore liberty was given to us to approach the civil court. Now, my lord, after the judgment, what is found, the lord, since 25/6/25 order, which is at page number 54, my lord, kindly see, my lord, in view of the stay order by Labour Court, Kamrup, Gauhati, in case number so and so, the competent authority has put on hold the transfer order of Nishan Anand and redesignated him as credit manager, Gauhati cluster, until aforementioned stay orders are vacated. So, my lord, ultimately, my lord, on 25/6/25, I was brought back to Gauhati. In other words, my lord, by necessary implication, the order dated 24/4/25 stands modified. So, my lord, what we challenged before the two petitions, before this honorable court was order dated 24/4/25, not this order dated 25/6/25. So, therefore, my lord, there cannot be any question of constructive res judicata or bar of order 23, rule 1 CPC.
In the present proceeding, what are you challenging?
Challenging, my lord, both the orders 24/4/25 and 25/6/25. Exactly. Therefore, my lord, kindly come to our prayer, my lord. Our prayer is at page number 19. Prayer, my lord. And if your lordship should kindly read the last two lines and the impugn order dated 25/6/25. So this was not challenged in the earlier two petitions. And this order is a clear demotion, my lord. I am a cluster head. I cannot be made.
Where is the 24/6?
Yes.
24 earlier order.
Yes. The earlier order is at page 38. Lordship should kindly come to serial number 12 at page 38. Kindly see Eastern Regional Office, Nishant Anand is the petitioner, cluster here, Gauhati cluster, transfer non-performance. Credit manager Kolkata. Credit manager is a demotion. And this time, my lord, by 25/6/25, I am brought back to Gauhati again as a cluster manager, credit manager.
Credit manager.
Credit manager.
Not as a cluster.
Not as a cluster. Therefore, in my humble submission, my lord, since my condition of service has been violated, therefore it's a fit case where lordship will provoke the power. Yes, had it been a case where I have challenged 24/4/25, then certainly, my lord, this
You
is
have
not
already been given liberty to proceed.
a civil court.
Civil court.
No, I just pointed out. At that point of time, it was not alive to our mind that we did not challenge 25/6/25 order. Subsequently, when we realized that we have not challenged 25/6/25, so therefore 226 is not a bar. Yes.
Said you go in
Civil court.
Why don't you go in civil court?
From that civil court, had it been a case per se of 24/4/25, we would have gone. We would have no option there. But because they have also challenged 25/6/25, there is no bar below. And my lord, how can I waive my right? As a counsel, I cannot waive a party's right. End of the day, if a writ petition is otherwise maintainable, why not? Because LIC is an authority under Article 12.
What was challenged in the
24, 425.
693.
Yes. Yes, proceedings before the labor court. That we are not disputing, that we are neither putting into challenge because maybe that is the correct position. That's why this liberty was given and it was extended for 10 days.
But liberty was extended only for the process.
That does not take away my right to will not approach any other appropriate court. It's true. Because that aspect was not alive to our mind. To be
But
honest.
then you could argue that this liberty is not applicable because this is the threshold.
Yes. That's why I said,
Therefore,
there are series of judgments of the Supreme Court. Normally, had it been a case where in respect of 24 for 25 we would have come, suddenly there is a bar.
Now the coordinate bench has held what? That guns is not covered under 2A.
Then London single judge was of the in 4693 that it is not an industrial dispute. Therefore, labor code could not be invoked.
Because it is not covered under 2A.
But in fact, there is a judgment of the Supreme Court, my lord, on this point. If a lordship would kindly have 2007 7 SCC 65. Lord will kindly come to page 70.
70.
Yes. Para 19. Was dealing with without order 23 rule 1 of the CPC, same provision, In fact, because of order 23 rule 1, that we say why liberty is required. In view of the above judgment, the position in law is clear that when court allows a suit to be withdrawn without liberty to file a fresh suit, without any adjudication, such order allowing withdrawal cannot constitute a decree and it cannot debar the petitioner hearing from taking defense in the second round of litigation as held in the. So without merit, my lord, then it will not open it as a part. So after considering all these things, my lord, we decided to approach your lordship. That is how we are before you.
You are now presently in Gauhati.
Presently in Gauhati.
Whether it's not a creature of any statute, neither it's a government company, as defined under section 45 of the Companies Act.
Therefore, no public duty.
My lord, even, my lord, assuming that I will say that totally private commercial activities. My lord, we take, my lord, money from the
You are
customers.
questioning the maintainability.
Exactly, my lord. I'll satisfy your lordship. This rate petition is not maintainable. And keeping back in mind, that the learned similar has passed an order, go approach to the civil court. And first of all, it's not a creature of statute, unlike my lord LIC. Under the LIC is under the LIC Act 1956. It is purely a company incorporated under as 12 Companies Act 1956. Now, the company that my lord is a government company. So, you must find that Companies Act has that 2013. Government company it is defined. Government company means any company in which not less than 51% of the paid-up share capital is held by the central government or by any state government or governments or partly by the central government. And
Dr. Sure notice here today you raised your objection.
the only thing, my lord, when it's out and out, they're covered by the
It's a division bench judgment of the Kerala High Court where it says this.
My lord, Kerala High Court decision has not gone into the Supreme Court decision which was cited there.
And it's similar para 11.
And that decision is the total misconception of the learned judges.
Considering the shareholding of the life Insurance
And it is
Corporation,
before pending before the
we are of the view that finding of the learned single judge holding LIC not to be a state reflects a complete misappreciation of law and suffers from erroneous reasoning, inasmuch as judgment relied upon pertain to banking institution without adverting to the articles and memorandum of association. Moreover, aforementioned provision of so and so, much less this shareholding, have also not been referred to judgment. In this matter, in this view of the matter, we overrule the objection raised by respondent so and so that it does not fall within the definition of state. Thus, whole it is a state. Privacy, this view is Lord, it has a persuasive value. It's not a binding, precedent. Even BCCI has been held to be a state.
Yes, BCCI in what way, my lord?
Yes. Side on this. Just a passing thought. This is the dispute. Say shareholder voting. I see.
Under the statute.
Statute, etc. See, this pure and simple case of an employee versus employee.
Here, since the condition of service is involved, therefore, Article 309 and 311 will come into. Here, we are questioning the violation of. We are not questioning the transfer per se. We are saying I am a cluster head. How come you have initially sent me to Calcutta as a credit manager? Then you again brought back me from Kolkata to Gauhati as a credit manager.
So there are
two
credit
views. Manager who.
One is a very liberal view.
Yes.
That why not under the why not amenable to whatever has to be in public interest.
In fact, Milord, they discharge function which are of utmost public importance. So say, if LIC is an authority under Article 12, why not LIC Housing Corporation? I'm appalled to hear this.
Lord,
if LIC is not, that's a different issue.
Possibly, my lord, my learned friend did not go through it. LIC is, my lord, under LIC Act 1956, that's under statute. And the LIC housing is not incorporated under the Companies Act. So therefore, these are the distinct areas, one has to go to that. And another thing on merit, my learned friend is saying, he has been demoted, it is not, he lost the time. I'll go to the merit.
Just 1 minute. My learned friend says, LIC is an authority created by statute.
Yes.
And Housing Corporation is not. Lord, let us recall, Milord, the judgment of the Justice Bhagavati in International Airport Authorities case. What did Honorable Justice Bhagavati say? Honorable Justice Bhagavati say that in the modern day, the activities of government has increased manifold. Therefore, the concept of the state enterprise came in. That could be by a statute or it could be registered under society's registration. And not under what statute an entity is formed. That is not decisive of whether it is an Article 12. What is decisive of is what is the nature of the function which is being discharged. Let us read, my lord, International Airport Authorities case. The concept of state enterprises developed from that judgment. This is precisely the reason why, because the activities of the government increased manifold, the bureaucracy was not good enough to handle. Therefore, this concept of corporation came into being. And they are the extended arm of the government only. To say, therefore, that it is either not state or authority under Article 12 is a serious error.
Today's context.
Yes.
These are all high sounding.
Not high sounding. These are the
legal facts. Apply in this case. The lordship will find right which purely originates from private law.
We decide on that.
Here, what happens?
It is for us to decide whether we can
Exactly
extend our jurisdiction or
that's
not.
the thing I'm pointing out. If the right accrues to you, the company has transferred you out to Kolkata, it's a private right. Regardless the fact, my lord, as the lordship will say, they are discharging public functions, which I am saying not at all. These are all private activities carried on by the bank.
We'll examine that. For today, we'll issue notice.
Your lordship, kindly give us a very short time. Within 1 week, we shall file our affidavit. And even in regard
is there any stay?
No, not. I pray for some status quo order till let me matter be fixed on an early date, I don't mind. Let them find their evidence.
My lord, even your lordship will appreciate in regard to supposing non-performance is transferred. Now, the appeals court is very clear. One can be transferred out. There are so many decisions.
They are arguing that this is not a transfer, it is a transfer.
Emotion.
No,
By
no,
demoting.
not at all, my lord. That's
That will
why
examine.
I'm taking your lordship to this. Your lordship can
That will
decide.
examine, Mr. Doctor.
The cadre is, my lord, associate chief manager.
Mr. Doctor, we are examining.
Yes.
Mr. All the respondents?
Yes.
For all the respondents. You are on caveat, Mr. Doctor?
Yes, yes.
First line.
Right, my lord, for all.
Mr. S. Doctor.
Lord, impugn order.
38.
30. 38 and my lord, 54.
Subsequent. Subsequent complaints. I will on the next reasonable date. Service condition. Currency in the present shall not be offered. And tell us which date is suitable for.
My lord, according to my learned friend.
Have it on 20 March.
Yes, a bit early. If it is on 9th of March.
Let it be 12th of March, sir, Thursday. If it is
Thursdays are
otherwise
reserved
on
for
the-
hearings.
Huh?
Thursdays are reserved for hearings.
Okay.
So
Then my lord, let it be on 11th.
11th or 13th.
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 13 is unlucky.
Lucky for some.
Lucky.
All right.
Why should it be
Deep
unlucky?
Always.
Perhaps the earlier order dated, which the Honorable passed on, have annexed on page 27. Okay? Page 27. Much relevant. But portion of the order is on Para 8, page 31. Yeah, read.
My lordship, earlier I had filed writ petition
Ah.
in February that my
What is your prayer in the present petition?
present petition is that in spite of that order that has been already settled, Honorable High Court has categorically stated that they have taken a stand earlier that they will appoint me. They have already had they have taken stand. The Honorable High Court has stated that they cannot change their stand. They cannot give a hot and cold air again and again. Now, my lordship, the present writ petition I have filed, they have issued executive order, that is the impugned executive order, is on page 43, and page 43 is the executive order that was passed in accordance with one notification, my lordship, which has a memorandum, my lordship, that also I have changed. Because of this executive order, my appointment has not been made. Whereas earlier, my lordship, Honorable High Court already deliberately considered all my contentions and all the state respondent contentions and came to the conclusion that they have already taken decision to appoint me and they consider my case. And they have filed also affidavit earlier. My lord, now this executive order, my lord, which I have challenged. Because of that executive order, my lordship, my case has not been considered till date, my lord. Because now the current scenario is that, my lordship, one memorandum has been issued, my lord. In that memorandum, in pursuance of that memorandum, one executive order has been passed. An executive order, page 43, my lordship. There is remand 2 can be seen, my lord. Page 43, remand 2. Application cases pending before DLC SLCs wherein office memorandum number APP.104 of 2019 dated 18/9/2024 has not been put to challenge before Honorable High Court as on 3/4/2025. Part after 3/4/2025 shall be dealt only in terms of office memorandum number APP number 104 of 2024 dated 18/9/2024 and shall be disposed of and intimated to the applicants by the respective DLCs, SLCs as the case may be. The order dated 3/4/2025 passed in WPC number P24 of 2025 shall not apply as precedent for cases that are filed on or after 4/4/2025 challenging the office memorandum number ABP 104 of 2025.
Now, after this order,
Yes, ma'am.
after 90 days, nothing
Yes.
happened.
I know.
After the order passed by the court bench,
Yes.
your case was not processed.
No, my lordship. My case already High Court has deliberately considered everything, and they have categorically
Page
stated.
number 31, there is a direction to consider your case.
Yes, my lord. And that
After
has not been done, my lord.
Not done.
Not done.
When
And-
was this order passed?
My lordship, the order passed on
21/5.
Yes.
25. Then yes,
Lordship, I just want to some chronological distance, Lordship. Lordship, the date of death in 1994, 8/1/1994. The case was rejected by the SLC in 2011. The petitioner came before the court in 2021, stating that this was not been communicated. From 2001 till 2011 to 2021, they were sitting, Lordship.
have you seen the order?
Yes, Lordship. Yes, Lordship.
There's
I
a
have
specific direction.
specific direction. They have other
they have
remedies
not
also.
filed appeal, my lordship.
Lordship, just
When
would have
there is
let
an order,
kindly.
when there is an order of this court, you are bound to carry it out. Or
It is
hold
up
appeal.
to it is up to them, Lordship, how they regarding this, whether they have presented it before the authority or not.
We have
I
filed,
am
my
not
lord.
aware.
We have
Then
attended the-
kindly allow me to submit.
No, I am just
Then
reading era
Lordship-
7 and 8.
Yes, Lordship, that I have seen.
Era 7 and 8, there is clear
That I have
direction.
seen. 7 and 8
It is
I have
it
seen,
is not
Lordship.
open for you to consider. You have to process it. That's the direction.
Then Lordship, there are other, that means, the executive instruction that what they are telling, that means impugning here, Lordship. This executive order is the outcome of a judicial order, Lordship. This was a complete direction by this honorable court, and accordingly, Lordship, to comply with the direction passed by this honorable court in a batch of writ petition, Lordship, this executive order has been issued, Lordship. And the executive order, Lordship, I think that my friend just has read, but this has to, in connection with para 4 of the parameters and criteria, that has to be looked into, Lordship.
But you also have to give an answer to what have you done in terms of direction.
Direction, Lordship, this was their executive order. Those whose cases were pending before the court, they were supposed to apply, Lordship. If they have applied.
Therefore, I am requesting you to go to para 7 and 8.
Lordship, I have said.
There is no question of applying. The direction is very specific. That there is a stand taken in the affidavit, process the case. Not even,
okay,
you do not have the liberty to consider.
Let them show that they have presented before the appropriate authority. Then I will obtain instruction. If they have presented it before the authority, I shall obtain instruction.
Page 46.
And presently there is no DLC or SLC, Lordship.
Which department is supposed to consider?
Home Department.
The Home Department one will file a specific affidavit as to the steps taken by the department in terms of the order it is right past it. 90 thereby such specific directions, sport for which the respondent again on 27th.
Deeply applied, Lordship.
So copies be furnished within 2 working days.
Highly obliged.
Applied.
Effect of referendum number 8.
So dated 12/2/2026 reads that it's not of the service on respondent. None is represented the respondent. State respondent will also be filed now. State for admission. March. Let it be listed on 27th of March.
Right.
Yeah, you go.
Yes, ma'am. I filed my objection, ma'am.
But they're originally the partners.
the partnership deed. Lordship may kindly peruse the page number 9 of my IA, where the deed of partnership is of 1998, wherein Sri Amichand Agarwala, Sri Vijay Kumar Agarwala, Sri Sankarlal Agarwala, Sri Anil Kumar Agarwala, Sri Pintu Kumar Agarwala. I am for Sankarlal Agarwala and Anil Kumar Agarwala. Lordship, in this deed of partnership, Lordship may kindly peruse point number 2 at page 11. Lordship, here it is written, the partnership is continuing. The partnership under these presents has and shall be deemed to have come into effect from 22nd day of June 1991, and same shall be carried on until dissolved. Lordship, the same thing in there, the partnership did they are referring to of 2023. They have also mentioned that this partnership is of 1991 and is a continuing one. In their supplementary deed of 2023, in their point 2, it is written that the partnership deed is continuing one and shall be deemed in have into effect from 22nd June 1991 and shall continue till such time as the parties hereto may agree. Lordship, my prayer is that I am a necessary party to this arbitration proceeding, so I must be impeded in this application.
It's clause for arbitration.
Page 20, my lord, of the arbitration application. Page 20 of the arbitration application.
20.
Page 20.
Page 20. I. The arbitration petition.
Yes, my lord.
You have not been served with a copy of the IA, but you file your
I have served copy. They have served. I have filed my objection, my lord.
page 20.
Page 20. My lord. Last paragraph.
Dispute between. What is the dispute?
Then presently there are 4 partners, my lord. The dispute is between my lord, 3 partners.
You have filed the petition.
Yes, my lord.
Arbitration
Yes,
petition.
my lord. They have come up for impediment, my lord. Yeah,
You have filed the 11-6 petition
my lord. Yes.
for
Appointment of arbitration.
appointment.
My lord.
Where is your notice?
Should find, my lord. Page 75.
75. And this is from three of the
Partners.
where is the deed again?
My lord. Page 15, my lord.
Partners.
Presently there are 4 partners, my lord.
4 partners.
My lord.
So who are you?
Supplementary deed of partnership of 2023, which my friend is referring. That is of 2023. These are the partners, and there was no dissolution, there was no retirement of any partner.
Have you challenged this?
Yes, Lordship, we have filed an impediment because if
Have you challenged the supplementary deed?
Lordship, we came to know that.
Then
So when we got to know that an arbitration petition is filed before the High Court, and we are not a party thereto, so Lordship,
what has
we have-
happened to the earlier deed?
They have been removed, my lordship. May see
Huh?
my objection, my lord. They have already been retired, my lord. And they have not filed their, they have not filed in reply to my objection, my lord. Lordship, this is my objection.
No, why should they file it? Where in which resolution have you retired in?
Lordship, there is no documentary proof. They have just stated that partnership has changed, but there is no proof.
Since 1998, they have not challenged it, my lord.
Huh?
Since 1998, they have not put to challenge any of it, my lord.
According to them, they have come to know only after you.
My lord, if they were the partner, if they were not the partners, my lord, let them produce the income tax document. They have that receiving the document, my lord. They are not the partners, my lord.
You have, there is some partnership deed,
My lord, it was in 1998, my lord.
98, or where you were a partner.
Yes, my lord, and they were also a partner, my lord.
Right. So,
My lord.
this partnership deed came to be altered,
Altered, my lord.
right? You are aware of that?
Yes, my lord.
So, where is the resolution for alteration?
My lord, see, page 18, my lord.
Oh,
Page 18, my lord, of my application, my lord.
the IA.
No, of the application, my petition, arbitration. Third paragraph, my lord. Second paragraph, whereas all the partners have mutually decided to execute this supplementary partnership on the demise of Om Prakash Agarwala. There was earlier deal, my lord, in 2021 also, my lord, when the Om Prakash Agarwala was one of the partner, my lord.
This mutually agree.
My lord.
Is there any document to say that they have given a consent to dissolve it?
No. But my thing is that, my lord.
Then this is the matter which is go before civil court and find out.
That's why they have to put this deed in challenge, my lord. They are the agreed party with the deed, my lord. They have not put to challenge the deed, my lord. If they are of the agreed, they have been wrongly ousted from the partnership with, my lord. They are due to challenge the deed, my lord. At present, there are 4 partners, my lord, out of which
No, but then why should we accept this supplementary deed in the absence of any document to say that there was a proper resolution where the signatories of the bank account in terms of the earlier deed?
No, presently, but all the 4 were there, my lord. 4 partners were there.
How many partners were there earlier? How many
Earlier there were 5 partners.
5.
Yes.
So who was retired?
Lordship, no one was retired. That is the issue.
All right. Who, according to them, who's not there now?
Shankarlal Agarwala and Anil Kumar Agarwala. I'm appearing for both of them.
Come to page number 21 of the application. Page 21 of the arbitration application.
I have had no.
Without having a copy, how will you file the IA? See page 21. The person with the photograph there is Anil Kumar Agarwal, who you represent, saying that he's been retired without knowledge.
Lordship, it is Pintu Agarwala, Ajay Kumar Agarwala,
Ajay.
and Anand Agarwala.
Anil, not Anil. I'm talking about the persons in
That is
whose
Anand.
presence it was signed.
This is Lordship Anand Agarwala. Page 27, the pen card is annexed. The partnership agreement, which I am referring to and they are referring to, is a continuing one of 1991. In their partnership deed also, it is referred that it is a continuing one of 1991. And I am also referring to the partnership deed where it is mentioned that it is a continuing one in the year 1991. So here I am just saying that we are a necessary party, and if the arbitrator is appointed, we should also be a party development.
Up to page number 18, says that decided to make this supplementary deed.
I understand, but the partnership deed was never resolved because it is continuing
So, who is
since
challenging
91. Yes, Lordship, we
Who
will be
challenging it?
challenging that one.
Hmm?
But if the arbitrator is appointed here, we will, our rights will be
Challenge you can show us that this challenge cannot be acted upon.
done, but we will do. But the thing is, we came to know before some time on. So we will be challenging
When
it.
did you come to know?
On 21/5/2025. We have stated in paragraph
That's
1.
more than 6 months, right?
Not sure if I
What have you
understand,
done?
but as per my instructions, is that if an arbitrator is appointed, we should also be given a notice and we should also be a party there.
The objections to your IA was filed on 21 January 26,
Yes, ma'am.
and you came to know in May 25. What have you done?
Not sure if I'll have to take instructions regarding
Please
that.
do.
Not sure if they can also bring, if there is a dissolution of the partnership deed, which I am referring to.
We are
Because
not here to decide which partnership deed is correct. Grounded is not a valid agreement. The counsel for the applicant seeks liberty to complete her instructions as it is submitted that supplementary partnership deed is is disputed. Supplementary deed scheduled after it's on 2nd of March.
Anything, my lord?
Right?
Around 6th March.
6th of March.
March. I did a lot. But, madam. The IR is for forwarding the delay, madam. Okay. The delay, madam.
Requirement to filing an application.
But as per the document, there is no requirement.
Huh?
As per the document, written document, madam, there is no requirement.
Okay.
But, madam, since there is a subsequent, madam, there is a long delay, madam.
Huh?
There is a long delay. Because we are
But is it necessary to file?
not necessary, madam.
Mr. Chaudhary? Is there a necessity to file delay condemnation in an IA as far as concerned? That's judgment still a good law.
I don't think it's required.
One, seven, X.
One more, there's a old judgment. The judgment of our High Court. Get it. Get it on Friday or Monday, whatever day. Friday. Don't change it. It's to be done.
Twelfth of February, instruction from
Or
For accountant general.
respondent 5. Anyone for respondent 5? As per Office Note 27/1/2026. Today, 16th of March. The instructions you have.
My lord, here the case was like regarding, my lord, for non-issuance of transfer pay slip by our office due to the non-furnishing the handing and taking over charge report with due signature of both relieving and relief officer on his transfer and posting as junior principal, ITI Tinsukia from ITI Bongaigaon. Now, as per Assam Schedule 3, Section 1, Form number 81, which is Certificate of Transfer of Charge, the signature of both relieving as well as relief officer is mandatory, but the charge report submitted to our office by the petitioner for issuance of the transfer pay slip was not in accordance to Rule 145 of Assam Financial Rule, as it did not bear the signature of relief officer in taking over charge certificate and the signature of relieving officer in the handing over charge certificate.
Place it again.
But I agree for about 2 months, the SP does for this one. I agree with that.
But we have filed an IA, my lord, for vacation of the order dated 8/6/2000, sorry, 23/7/25, my lord. Lord, it's a very simple matter, my lord. The petitioner is working as a junior district administrative assistant. She aspires to become senior district administrative assistant in the office of the deputy commissioner Nalbari. Something like, my lord, promotion from LDA to UDA. Now, my lord, her grievance is she is a general candidate. Now, the position which has been given to our client, that is respondent number 6, it is meant for SC, and I am a general. That is absolutely wrong, my lord. If your lordship would kindly come to para 20 of the writ petition. This is his case, para 20. That the petitioner begs to state and submit that Humeswar Deka SC has already retired from service after attaining superannuation from the post of SDAA, and after his retirement, said post was vacant. Thereafter, authority has promoted Srimati Midusmita Das, that is the respondent number 6, to the post of senior district administrative assistant as per order of promotion dated 9/6/25, but she does not belong to SC community. Therefore, petitioner has made Midusmita Das as a main respondent. Now, the petitioner's grievance is, how come in a SC post, Midusmita Das, respondent number 6, whom we represent, has been promoted? Now, this is not correct, Miller. If your lordship should kindly come to the IA, last page, page 33, we have given the DPC minutes, Miller. It was another lady who was promoted. Page 33 of the IA. And let's see the heading, action taken for promotion from junior assistant to senior assistant. Now, number 2, number of posts to be filled up 7, zone of consideration 28, we are not concerned. Please come to 4, roster status. As per roster register, roster point up to 109, 1010, 111. Kindly see 112 is SC and 113, 114. Lord, Humeswar Deka was appointed against 114. Not against 112. Now, kindly see down below. Committee decided to consider name of Srimati Devabola Bharali against the roster point 112 as SC candidate whose name was under zone of consideration. So, against the Supreme Court, scheduled caste vacancy, which is roster point 112, Srimati Devabola Bharali was promoted. Now, please come to the next page. A recommendation and observation. All the members of the committee arrived at a consensus to fill up 7 posts of senior assistant as there was no candidate of STP. Further, committee to decided to consider the name of Devabala Bharali against the roster point number 112 as a SC candidate whose name was under zone of consideration. Kindly see, serial number 6 is Homeswar Deka and serial number 7 is Devabala Bharali. Therefore, my lord, Homeswar Deka was not occupying any post meant for SC. That is the case of the petitioner. Therefore, my humble submission is, my lord, there is an interim order whereby lordship said that my promotion would not be regularized. That order can be modified and, my lord, my promotion may be made subject to outcome of the writ petition. Yes, the order is at page 29 of the I. The operative portion is at 32. Since the petitioner assails the promotion of respondent number 6, who according to the petitioner was promoted against a post reserved for scheduled caste category, despite belonging to general category, and considering that promotion is shown to be temporary, it is directed that authority shall not regularize the promotion of respondent number 6 to the post of senior district administrative assistant in the office of the deputy commissioner Nalbari, pursuant to order. So, therefore, the
You represent respondent
6. Vidusmita Das, my lord.
She is promoted where?
He is promoted as senior district administrative assistant. That means UDA. I am promoted against roster point 114. 114 is not an SC post. 112 is the SC post against which Devabala Bharali was promoted. Now, my lord.
In page number 30.
Yes.
So, stop.
Yes. No, my lord. No. What I am trying to say, just to, my lord, show that petitioner's premise is not correct, I have placed this. Regarding my, it is there, my lord. This is a DPC of, my lord, 2012. When Homeswar Deka was promoted, my lord, he was not promoted against any SC quota.
You are now promoted in the vacancy.
General vacancy of Homeswar Deka. Yes. So that is not a roster point meant for SC. That is a roster point meant for general.
Where is your findings?
1 second. I think in the writ petition they must have given. No, they have not given the minutes, my lord. No, my lord, this minute is necessary to disprove the petitioner's assertion that I was appointed against an SC vacancy. I was never appointed against SC. Page 34 is the order, my lord. Kindly see, this is very important. Page 34. In the vacant post of Homeswar Deka retired. So Homeswar Deka was not appointed against any SC. That was the general unreserved post. Serial number 3. 34. Page 34 of the writ petition. Nine 625. Srimati Vidusmita Das, Junior District Administrative Assistant, in the vacant post of Homeswar Deka. So 114 roster point, which Homeswar Deka was holding, Lord, it is a unreserved post. It is not a SC post.
I take a list. Please.
Petition 27 of
petition. The edition list of the staff of the district establishment. Field number 8. So Deka. Belong to SC. And last portion, remarks. He belongs to SC. He does not belong to general category, he belongs to SC category. And his promotion order also will find at page 34. Page 34.
34.
Page 34.
Yes.
Vidusmita Das, page 34, seal number 3. Vidusmita Das, again post of Homeswar Deka detailed. Got it?
Now they want to project that roster 113, 111 be filled up by general category candidates. According to them, roster register is not before your lordship. Secondly, lordship will find that cadre strength of senior division extent, that is the lordship, the post where it has been filled up. Cadre strength is 41. So reservation is permissible, reservation is 10 for SC. 2 posts has been filled up by the SC candidate. 1 post is reserved for SC. So he is entitled, petitioner is belong to SC category, petitioner is entitled for the post. And roster register has to be produced by the department. And there cannot be roster register of 117 when cadre strength is only 41. And already this court has decided and Supreme Court has decided when there is a conflict between the roster register and the percentage reservation, then percentage reservation will prevail.
If you come to page number 30 of the IA,
Page number 30 of the IA.
Here are the minutes pertaining to the selection of soda. Second last paragraph. Serial number 4. What's the point?
As per roster register, roster point 109, unreserved 110, unreserved 111 STP, 112 SC, 113 unreserved, 114 unreserved, 115 unreserved are to be filled up against 7 posts of senior assistant. Backlog vacancy, they have shown. The committee decided to consider the name of Srimati Devabala Bhorali against roster point 112 as SC candidates whose name was under the consideration.
Therefore, out of these extra points, only 1 point was reserved for SC.
My case is cadre strength is 41. Permissible reservation for SC is 4. 3. Permissible reservation is 3. Here, then senior division is then only 2 SC candidates are post. Total cadre strength is filled up. So there should be 3 reservation for SC candidates. 1 post should be reserved for SC. That post has not been filled up by general category. That is my case. The permissible reservation.
What is the stand of the respondent? Wherever students are meant to tell us what is the why are you trusting these papers under our name? Take it. Don't want to see your paraway for me. Tell us. Unreserved. But then in the so he was an SC person, filled up
By virtue of merit, it can be.
up an unreserved. Now, what is your answer to submission that number of extra points fixed for SC? According to it,
Can I make one submission? End of the day, my learned friend has to succeed in the writ petition, then only his client will get a benefit. Unnecessarily, my lord, a Damocles sword is hanging over my head. All that I am submitting is, my lord, these orders should be modified to the extent, and that promotion will be subject to out of the case. Because, my lord, lordship will normally will not stop a promotion. If he wins the case, there will be a review DPC where his case can be considered. Otherwise, my lord,
yes, but
no, my lord, that is not the case. Possible, kindly see.
but your
There, no, in para 20, his case is very clear. That why he says it is an SC post, because Humeswar Deka was appointed against them. But I have shown from the DPC minutes of the Humeswar Deka that it is 114 was not meant for us. So his entire writ petition is premised on the basis that 114 is the post, though that he has not mentioned, but he proceeded on the basis since Humeswar Deka is an SC, therefore it's an SC post. How come you are now promoting a general category candidate? That is not correct. Para 20, that's what I have shown. That particular. No,
Right, he's now made a submission, he gave the instruction. The roster points are not fixed as per the.
Below, kindly see under the latest act below, there will be only one vacancy. When the vacancy, the cadre strength is 3, then there will be only one SC. Kindly see.
What is the cadre strength of?
41. So 7% is 2.8. Let us take it 3. Kindly see that column of 3 below. If the cadre strength is 3, then SC will go only 1. It's an open and shut case below. How can? Since it is 3, therefore SC can be only 1. In a 100-point roster, it will operate otherwise. But when the cadre strength is less, this is how it operates. So Devabala Bharal is already there.
Yes. But you not needed that.
What I have needed, Lordship, is para 10. Para 10, what they submit without looking to the petition. The cadre strength of senior division assistant SDI in the establishment of deputy commissioner is 41. As such, as per provision of section 4 the Assam Scheduled Caste Scheduled Tribe Vacancies of Service Act, and there should be 7% reservation for the candidates belong to the scheduled caste.
So how many posts?
41.
7% would be?
7% of the 41.
2.8.
2.8. Now there is only 2 candidates in the
They are getting more than 1. What is like?
Right, let them get their instructions, we'll consider this application. Get your instructions as to the cadre reservation. That to para 10. Respect of these posts, how many posts?
No, how many incumbents are now holding, and according to their circular, how many SCs should get. And in any case, Milord, his case is other anyway, not to take it on another date. I am not on that. His only case is because the Homeswar Dekar was SC, and now Homeswar Dekar post has been filled up by an unreserved.
Now he's come up with another additional view that.
The answer is that, Milord. If it is 3, cadre strength is 3, then there will be only 1. That they are already having 2. So there is 1 more SC. Going by the latest 2012 Act.
When can you get it? $7.25. But there is no restraint on your promotion, only regularization.
No.
I can order. And, six. Stop state administrative assistant in the office of 6 without six submitted by Mr. The price of the challenge. See, the petitioner. Six does not. SC category. Submission of the petitioner. Where is the
Page 33, my lord, of the IA. 1030. DPC minus.
DPC minus dated 11/7, 8/6/2012. 7 persons were promoted. Same DPC, there is a stop points. Specific decision that one Srimati Devobala that C minus concerning the promotion stop point. File your objection here. Of objection. SC category. Get a spending 41. 41. Take a council. Stop point. It's as regards SC category is not maintained. Let this matter be listed on
27th, my lord.
2nd of March.
My lord.
Oh,
No, no, you take it
27. All right, 27.
Yes.
Mr. Bora, 27. Get the instructions. State council. Got the number of stop points. But its category is concerned.
Senior district administrative assistant. Assistant.
Regarding cadre strength and how many candidates are here?
I'm the petitioner and the respondent number 6, the co-wife of late Shamsul Sarkar. Lordship, here what happened? We were both the co-wife of the late Shamsul Alam Sarkar. Lordship, he was serving as a Gaon Panchayat. After that, he was died in harness 29/07/2001, my lord. After that, we have lived together, my lordship. The respondent number 6 with the husband, with the wife, and I'm the second wife, my lord. That from 2001 to 2023, my lord, we lived in the same household, my lord. After that, thereafter, my lordship, we lived separately, my lordship. So initially, my lord, the respondent number 6 given me assurance that he will 50% divide this concern amount, my lord. And thereafter, though he given a notary before the district Hubli, where he
First, she stated that she will give 50% pension amount to me, my lord. And my lordship, as per the judgment of this honorable court, Junuka Bibi and the recent judgment I have addressed the Monoara Khatun, in the judgment, my lordship, this honorable court said that if there is no dispute between the marriage, then the pension amount will be received by the first wife, my lord, but that amount will be shared to the second wife, my lordship. That is my prayer before your lordship. Thereafter, my lordship, I have submitted the representation before the director of pension, my lord, and my lordship, another submission I have given before the
That is also settled in Surupa Bibi that.
That is all right, but the direction has to go.
That would be between the two wives only.
First wife, the respondent here.
replacement.
Respondent, husband.
2013 lordship, standing.
13.
My lord, immediately after the date of his father, he had filed a petition for constitutional. My lord, our honorable High Court passed an order. My lord, kindly come to page number 25, my lord.
There is a direction.
My lord, direction. Direction, my lord. Same self. The respondent number 5 on receipt to the same self place.
And what did you do after that?
Then, my lord, they did not consider my petition, and that's why, my lord, filed also contempt, my lord. And in that case also, my lord, honorable court, my lord, PLC directed the DSC, my lord, of consideration of the order passed by honorable High Court, my lord, and the DLC said the matter, but Lord, in this regard, my lord, Profi Roman says also, according to my lord, 15 also, my lord, office number 1. My lord, there is no in that office. My lord, any other office, we appoint the commission appointment, but in the point of my lord, on the ground, here, my lord, clearly said all GLCs and SLCs directed to take into account the overall vacancies available in all the departments and therefore consider such vacancies against all the application on the basis of industry financial compensation. Such consideration be made irrespective of the department wise, my lord, or office wise, where the disease that earlier served. My lord, this is the head of the administrative department. So, my lord, he has the empty power to see any other department.
Page, concerned page is page 30, lordship. Start from page 27, but the concerned page This column 6, Lordship petitioner. Considered on the basis of 1/6/2015 OM, though as per several judgments of Honorable Supreme Court and this Honorable Court also, they are not covered by this 2015 OM, Lordship, as the date is prior to 1/6/2015. And that apart, Lordship, if we take it this also, Lordship, this clause 10, principle 11 also is there, Lordship, of the 2015 OM, that if the case remains unconsidered for 2 consecutive years, Lordship, for want of vacancy, this will not require any fresh consideration, Lordship.
But
And-
it was sent to the administrative department.
Yes, Lordship.
What
And
has the department done? Administrative department.
there,
Let us the information. Sent to the case that you examined and you found no vacancy. What it is that information
not required here, Lordship.
the DLC has already
Considered, Lordship, as
considered.
per direction of this Honorable Court,
And that
DLC
is-
has
that
considered,
is
Lordship.
evident from the
Yes.
order passed in the contempt petition.
Yes,
also.
Lordship, the last page, Lordship.
Not,
This is there.
Power to see another departments also. So my
Yes.
lord,
But that was sent in the year 2015.
I will file this petition on the.
You filed it in 22.
No, my lord, earlier also it is second, this is my lord, second time filed by the petition, my lord. First time already decided by the Honorable High Court to consider his petition, my lord. Honorable High Court order, my lord.
It was considered, Lordship. This case
Consider
30.
then again, and contempt is not clear, but my lord.
Yes,
contempt is
contempt
not
You get
clear.
the information. Serial number 7. What has this committee done? Two parties. In deference to the High Court. So far, the report. Percent of the on 2nd March.
Highly obliged.
Some more time. 16 March.
Highly obliged.
It doesn't.
not entitled to any.
Bring it on record.
It's all about page 14. The condition number 2. Condition 2, the workers will draw wages under the heads of accounts salary as other regular employees of the government for administrative convenience. However, these casual workers will not be considered as regular employees and no such claim can be made on this basis. Regularization. Yes,
Name of the petitioner. Serial number.
17.
Say you- How do you take for pensionary benefits? State again.
Okay.
Died on the disputes arising by dispute of the agreement. Submitted a written declaration.
Take the mark.
We have see. Evidence against. Steps taken?
Steps taken and they appeared at the time of motion itself.
Yes.
Your Lordship, I'm representing on behalf of eight. I'm representing on behalf of eight.
Step alia.
Already our consent has been terminated.
2nd of March.
Same. Item 27.
Same.
Respondent authority erroneously retained the petitioner from service on 31/12/2018. Lordship, he ought to have retired in the year 2026. His date of birth was actual 21/6/1967, but they have replaced his date of birth in his service book after a lapse of 13 years.
The authority is trying to correct a mistake of birth and to have
They have corrected.
correct my
They will
mind.
correct.
Yes.
Then you reinstate it. Seventh of March.
There is one communication of 2022, my lord. From the forest department's part, my lord, we have submitted the fund demand. One clarification, my lord, we sought from the member secretary of referral medical board, GMCA, regarding his admissibility. When was he admitted? Because two communications had given different admissibility. 50 days.
You are required to submit this
Uh,
for reimbursement.
yes, ma'am.
You are required to submit.
Then forest department will sanction it, ma'am, once this is cleared.
This was issued
September 2022. After that, ma'am, we have not received the reply. If we get, my lord, we can then process further.
in management for some amount.
That's 40,160.
For the last 4 years, you're sitting over it.
Once we get this, my lord,
What do you mean once? The employee,
forest department.
is he entitled to make a claim for reimbursement or not?
Yes, ma'am. Only that
So
clarification.
that clarification has not come for 4 years. Gentlemen asking for clarification under secretary.
Yes, ma'am. From the GMCs, ma'am. If we get that, my lord, we.
No, it's not a question of if you get it. Either you ask the petitioner to get it from the DMC, not suitable for 4 years on the ground that it has not come. And if you get it, you will pursue. Yes. Get your instructions or we direct your secretary to be present. On 2nd of March, get instructions.
This may be recorded, my lord. This communication then.
In terms of the last order, Mr. I got please to go. 26 September 2020. By request was sought for from the Undersecretary Department. Secretary and as to the accessibility. This can be taken.
I'll also
You take a copy.
Yes, sir.
It's the new woman. It's taken on 2nd.
Okay. Okay.
Lordship, before that, I just want to, Lordship, to go through the page 68, Lordship. And I pray that Lordship makes some observation.
68.
Page 68, Lordship. Ten 12, Lordship, the same petitioner. The petitioner was,
Making the
petition
same,
was
same,
same,
prayer.
Lordship, same.
Why?
This.
Also, actually, we were as counsel unaware of this case which has been annexed as C for the
Order is of 10th December 2025, Lordship.
we were at that, Malord, we were unaware as counsel. So the petitioner previously in 2018, he appeared for him, but in between,
Third counsel for parties will be submitted that sent to the filing of the affidavit. File. Appearing for Supreme Court.
Jobless lot.
That sanction has already.
Avinash Baskar. On 13/2/2026.
But they are represented by their legal guardian, by their grandmother.
Respondent number 2.
He's a minor,
Is respondent 2 here?
Avinash Baskar.
Is petitioner.
Sorry, petitioner number.
Is sanctioned in favor of
grandmother, That's fine.
Kausalya Baskar.
Then for March,
7 March. 7 March is Saturday. 9 March.
9.
no,
Bulwa for
Transport is going to be 5.
of regular. Lordship, I have received instruction in this matter, Lordship. They were unaware about the order passed by the appellate authority, Lordship.
which order? 16
Yes. Yes, 16 to order, second page, Lordship. And in Lordship, the information copy, Lordship, para 3, the circle officer of Bagbal Revenue Circle has been the necessary action, and the petitioner was asked to hand over the charge of
Where
garbage.
is the order? Where is the order? Appellate or review?
Central.
7.
Jill Hawk.
Private respondent, Lordship.
So you did petition the proposed.
Yes.
No, that's not the direction of the appellate authority. Or fresh.
It is already been handed over to, I think, another.
Third learner. Challenging. Seeking direction. Appeal dismissed or allowed. Specific runs of the report.
Chief Organizer.
Submitted that. We fix very well. The guidelines.
Guidelines, page 23. Page 25 is the criteria for. Village. Secondly, also a meeting was not convened by the secretary. As per the Panchayat Act, every Gausava meeting is convened by the secretary, section 4. Selection process is also given in the guideline, same page. Serial number 4. A meeting of the Gram Sabha would be convened to select one out of the 3 shortlisted names. Minutes of the approval process in Gram Sabha shall be recorded. The Health Committee enter into an agreement with ASHA, as in the case of and Sharmagini, Sharmasik Sharmajan. Name will be forwarded by the Gram Panchayat to the district nodal officer. Now, before that, there is a process of as stated in the serial number 1, 2, 3 that has to be shortlisted. It was also not done. However, I have also submitted application initially to the respondent number. It was not accepted. 5. Respondent number 5. Subdivision and medical it was not accepted. But at the time when the meeting was going on, a meeting was held under the presidency of respondent number 10, who is the husband of the respondent number 6, president of the Gauh Panchayat. That application was received. Page 34 is the application.
Oh, you are challenging the appointment of private respondent.
Private respondent.
That he is not the resident of the village.
Village.
Where is she?
She is at different Ambikapur 11, part 11.
Are they represented by the council?
No, service was complete, but the
Service complete. Stand of the respondents.
respondent number 3 has filed affidavit with joint director. They are saying that everything has been done as per procedure. The meeting was held.
But regarding the residence of private respondent,
they are saying the house of Kalpana Pal is situated in the part of Ambikapur, part 11, admitting. They are saying the ASHA survey report which was conducted by the late ASHA Chandra mother, which shows that the house of the Kalpana falls under the area of ASHA. They are saying they're in the same area, but she is from different village. But the ASHA was appointed for village Uttar Krishnapur part 1, which is a different revenue village. Another important thing also, by way of RTI application, I have obtained information that Secretary has replied of the Gauh Panchayat that on particular date no such meeting was held.
That means meeting was not convened by the secretary, which is sorry, as per the section 4 of the Panchayat Act. They wants to apply RTI information.
Who's number 9 and 10?
9 is the respondent number who is being appointed as National Worker.
And 10?
10 is the husband of the president of the this Panchayat who has decided over this meeting.
President and husband.
President is by designation respondent number 6.
President is respondent 6.
Respondent 6 by designation. Respondent number 10 is the husband of the president who has presided over the meeting.
Now this is to be supervised by whom? Meeting?
Meeting as per Gauhati Panchayat Act by the president in his absence by vice president.
In terms of your guidelines.
It's a Gauhati meeting. But guidelines says it should Gauhati meeting. Gauhati meeting is guided by this section 4 of the Panchayat Act. Says page 25, Lordship. Number 4. The Gram Sabha would be convened. Gram Sabha is to be convened by the secretary, decided over by the president or vice president or any other person. Is there, is also there, but or any person to be selected by the majority of the Gauh Sabha member. RTI information furnished by the secretary says the Gauh Sabha meeting was not held on particular.
Who is the block nodal officer?
Nodal officer would be point reactor. It's point number 5. Deputy Commissioner.
District Health Society? Yes. Deputy Commissioner. Number 26. District Health Society under the chairmanship of District Health.
President Jilla President.
Instructions.
We have applied for this secretary.
NHM minutes are available.
It's the guidelines published by the going to mark. This response number 5 is health, primary health, block primary health center, under block primary health center. Submitted that in turn. Senior prescribed for selection process. Mother, my mother. Some survey conducted. They are saying, but no document has been. Paragraph? Paragraph 8, no, so page 69. Second paragraph. Okay, second paragraph. According to the survey report. Therefore, it's all necessary documents. But in Comes from.
There's also
Dated 3/10/2021.
survey report.
Within 2 weeks. March. Okay. We approached that immediately after retirement, when the provisional pension was started, there was an attempt made for recovery, saying that the HUDCO, I have a loan, I have a loan of tax from the HUDCO, and unless that is recovered from my pension benefits, my pension would not be. You did not appear for mediation. We appeared for mediation. The report says none of the parties were present. There. We were there of finance and the other departments. In fact, HUDCO was also there. It says neither parties nor council contacted the mediator. Is there a requirement for contact? Was also there. And HUDCO had given us a proposal that now if my pension and other benefits are released, then I can settle the loan with HUDCO also. There is a title suit pending. We can mediate it there in the title suit, my lord, and get it settled there. The PWP. Well, I was serving in the PWP. And you superannuated it? It was a UDC, number delegate. Why is your pension not released? Pension not released because at the time of my retirement, HUDCO wrote to the PWP saying that there is a loan tax which I have to repay. And to that extent, there is a title suit pending against me, title suit 367 of 2009. For recovery. For recovery, which is still pending, my lord. Civil court. Is that normally attachment can be made in some circumstances under order 30 and here, my lord, I am protected as far as pensionary benefit is concerned. 60 of the CPC, my lord, 1C. Specifically, my lord, protects gratuity and pension. That cannot be directly recovered from my pension. There can be other modes of recovery. And in fact, if I get my pension, I can settle it with HUDCO also. For 6 years, my lord, I will. So,
My lord, I will, there, since my lord, HUDCO filed an affidavit, my lord. I have just writing instruction. Then this my lord is between HUDCO and the petitioner.
I mean, then PWC is not. At the instance of HUDCO. It is there, my lord. No. Have other modes of recovery. Who's for HUDCO?
Letter to HUDCO, written by Executive Engineer PWD, Corporate Building Division. I have the honor to state that loan amount sanctioned to the Dilip Kumar Das, LB, from your end will be recovered from his monthly pay nil in regularity. That letter, based on that letter, my lord, my lord, page 70, the same petition. Statement is doing the outstanding amount of loan. What full amount was only they are seeking to, in a way, attach my pension so that the full demand can be set. Get my pension, my lord, I can come and very well mediate the matter before the civil court. But he was stopped. Para 33 law. Para 33.
Where the papers processed. No. He did not receive anything.
Provisional pension.
Huh?
I'm getting the provisional.
Getting the But is there any order of provisional pension?
That is not disputed. That is why they the case of tender.
page 15 is the provisional pension order.
recovery was made.
That is a subject matter of the suit. I'm not disputing the loan. I think so.
Find the title suit.
But for my lord,
Retirement after.
that was before my retirement. 2019.
Disputes arose.
'67 or 2007 or 2019. Still there's one. First February 2020.
First February.
15, my lord, is the provision. 2020. Right. Next of 5, 16/6/2020 is the page number. It's number 22. Deduction from my provisional
State.
state. Gets you.
Independence.
Decision is done from the executive engineer. The three will
Respondent number 3, report. Final report. Not any confusion. This order in the DP was carried in a writ petition. The writ petition was dismissed, and that order in the writ petition was then carried in a written. The appellate court came to a finding that the petitioner had completed more than 20 years of service, and therefore the punishment imposed on him was disproportionate. And accordingly said that the disciplinary committee shall reconsider and try and reduce the punishment. Here at this point, I must point out, my lord was part of the division bench which passed that order. Just I'm pointing out to my lord. Now, after the order of division bench, I went to the employer, that is SBI, and I said, now that as per this order, kindly give me the pensionary benefit and superannuation benefit as per this order. The bank comes to a conclusion that no, you have not completed 20 years of service. The rules require 20 years of service. You have only completed about 14 years of service. And says, therefore, you are entitled to gratuity, you are entitled to PF, but you are not entitled to pension. Being aggrieved by this communication of the bank, I have come in the second round of litigation. Now, this matter, my lord, was heard on the last occasion, and the bank was directed to show any document which substantiates their contention that I have not completed 20 years. The division bench finding is I have completed 23 years of service. The division bench also records that during the course of the appeal, the bank was given an opportunity to produce my service record, which was not produced. So, after taking the whole facts into consideration, the division bench says that the appellant has completed 23 years of service. It is only after this order that the bank now says that you have completed 14 years of service and therefore not entitled to pension because the rules require you 20 years of service. But order in the inter-party order, which is attained finality, there was no challenge. My lord, at page 72. It starts at 72. My lord, comes to para 11 at page 76. First for para 9 at 75, then I'll come to para 9. May I read? We are also of the view that there cannot be any doubt of concern raised by the bank about such a conduct of the appellant.
However, we have also taken note of the fact that the Appellant Act did not result in any pecuniary loss to the bank, nor is there any element of doing any favor to any member of the public banking which would tend to lower the prestige or goodwill of the bank in the eyes of public. It was certainly an act which was not expected of an employee, but we also have noted that the appellant has readily admitted to his charges by not contesting the same, and had tried to explain the same by stating that he had utilized a part of the said loan amount for purchasing a plot of land and constructing a small house for his ailing old mother. Now, para 11. May I just say, the background of the DP is this. I had taken a loan from SBI, my employer. They say that I did not utilize the loan for the purpose it was taken. That DP was drawn up. I did not contest. That DP culminated into a dismissal order without superannuation. 11. We have also observed that the appellant has been serving for the last 23 years in the bank, apparently without any adverse remark or report. Though we had given several opportunities to the bank authority to produce service records of the appellant to enable us to see whether it contains any adverse report or indicates any unbecoming behavior of the appellant, the bank has not been able to produce his service record. And as such, in view of the categorical assertion made by the appellant that there is no adverse remark or report in the past service, we take it to be correct in the absence of any record contrary to the same. Now, my lords, will come to paragraph 13, paragraph 12, and then 13. Paragraph 12. If the appellant has served for 23 years without any adverse remark or report against him, we are of the view that dismissal is the highest form of penalty which would entail denial of any service benefits, including pension, perhaps may amount to be very harsh. We also have taken into account that by the aforesaid misconduct of the appellant, no pecuniary loss was caused to the bank. We have also taken into account that it was an internal administrative act of the appellant which did not come to public limelight, which could have caused embarrassment to the bank. We have also seen that the appellant at the first instance has apologized for his misconduct and also offered the reason for doing so. Therefore, under these circumstances, we are of the view that the denial of benefits of the entire past service rendered for 23 years perhaps may amount to too harsh, considering the mitigating circumstances as referred to above. Now, 14, madam. With the above observations, we remit the matter to the bank authorities to reconsider and for passing appropriate order of penalty without imposing the penalty. Consequently, the impugned order of dismissal challenge will be subject to the final order that will be passed by the bank authorities in terms of the order directions made by us as above. To that extent, the impugned order of the judge stands interfered with. Further, by considering the facts of the appellant has been out of service since 2010, who is looking after his ailing mother, the bank authorities are expected to pass appropriate orders as expeditiously as possible in a further video. Now, pursuant to this, I make an application. Pursuant to this, at page 81, the disciplinary authority modifies its order, page 81. Relevant at 82, my lords, 82, the portion in bold. Be discharged from service with superannuation benefits, that is pension and or provident fund and gratuity, as would be due otherwise under the rules or regulations prevailing at the relevant time and without disqualification for employment in terms of there are 60 of so and so. Now I make a representation that kindly give me the benefits of pension, and at page 85 is the include communication. With reference to your letter dated 15/11/2022, like to advise
Pursuant to the order.
That order, my lord, will find at page 80. 81.
80. What was the...
At 82, if my lord see. At 82, the portion in bold. Be discharged from service with superannuation. Earlier it was dismissal without superannuation. Now it was discharge with superannuation. And based on this, I make an application for the superannuation benefits, which is rejected at 85, which is included in the at 85, page 85. With reference to your letter dated 15/11/2022, we would like to advise that an amount of rupees 155,950 PF oath contribution has already been paid to you on 28/9/2022, who are entitled to PF contribution, bank's PF contribution of 32,024. Our Fancy Bazaar branch has already advised you, we did an email dated 21/11/2022, submit stamp money receipt and stamp indemnity bond to enable them to release the bank's contribution. As regards payment of gratuity, please note that the bank has approved proposals of
sent to you. Now 4, this is relevant. As regards the eligible pension, be advised that you are not eligible for the same as the total service in the bank after deducting the authorized absence comes to 14 years, 11 months, 20 days. Now, there is no record which has been placed either before the division bench or either in the first round of litigation or even before my lord, which shows that I have not completed 23 years. That is the first submission. Second submission, my lord, the division bench, the finding of the division bench or the conclusion of the division bench came from a finding that I have completed 23 years. That was the thrust. Because I completed 23 years of service, the punishment of dismissal without superannuation benefit was termed as harsh. Now, on the last occasion, my lord, the matter was listed on 2/2/2025, 26, my lord, has the order of 2026. There are 3. The matter has been heard only at the request of Mr. Saiwala, as considered to produce the relevant documents by which the petitioner was placed under suspension and the order by which suspension was revoked. The matter is fixed on 11th February. Now, what happened is, they have not produced any record which shows that I have not completed 23. My petition is based on the division bench finding. Now, on the last date, because when the DP was ongoing, they had suspended me from service. And they said, you are suspended, but you cannot leave the service of the bank.
No, under the rules, which mention end of legal. When is pension due?
Pension is due, minimum requirement is 20 years of service. That is there in the rule. Provident fund and gratuity can be for less than 20 years. It depends on the total number of years that I have served. As per them, 14 years. So at page 85, the figures that are mentioned, that is calculated for the period of 14 years, 11 months. But my contention is that 23 years of service today is a concluded finding which has attained finality.
Yes.
Hello. Let's get to the what is pensionable service? There is a difference between service and pensionable service. No period of leave granted without leave salary absence, without leave shall be counted as pensionable. Now, my lord, the division bench order was with respect of the services, and that final order was again assailed, and that one order was passed. This is there at page 81. That is not before a lordship. My lordships have to understand one thing, that my lord, that the pensionable service is of 14 years and some months. So it does not cover that 20 years. Shall show from their own records that neither he was ever suspended, nor it has attained 20 years, so as to enable us to pay them the pensionable salary.
But this argument you should have made before the division bench.
No, my lord, because that was not the issue there. That was not the issue there.
There is a finding that is 23 years.
23 years of service, but not 23 years of pensionable service. There is a difference between service and pensionable service.
Finally come to 20.
My lord. A member of the State Bank of India employees pension shall be entitled for pension rules 22(1) while retiring from bank services after completing 20 years of pensionable service. And what is pensionable service? My lord says at page, what I have given the annexure 1 at 109. No period of leave without leave salary absence, without leave shall be counted as pension. So all unauthorized leave will not be counted. Suppose a person gives a service of 23 years, let us assume, but he does not turn up for 5 years, 4 years, 3 years. Those period will be deducted.
So what are you giving now?
So whatever is entitled, we have given.
What is the entitlement?
My lord, the entitlement is that.
According to you, is not entitled to pension.
Yes, correct. Otherwise, what is the entitled, we have given him.
What is the entitlement?
Under what? Under what category? Entitled to some money, we know.
Yes,
You know, I know.
Madam.
But under what head, what category are you?
Under PF contribution, Madam, you have given?
PF contribution.
Yes. And under gratuity, we have means we have said that you come and give that money receipt, and perhaps I don't know if they have taken or not taken, but this we acknowledge that this is the amount that is entitled. Only in respect to
But
that,
reading the order,
Madam. Madam.
doesn't appear that there was any attempt service, pulses, and pensionable.
Correct, Madam, because the reason that was not the issue before the division bench.
True.
He only challenged the award copy that this award is not sustaining. So the only the final order was under challenge. Now the final order of the disciplinary committee. That was page 61. This was challenged. The single bench said no, will not interfere. The division bench interfered and passed an order. Now, my lords, when the order was passed, subsequently that is also not under challenge. It has attained finality. Now, my lords, may kindly see 82. What has attained finality? 82 it reads, we discharge the service from superannuation benefits, that is pension and or provident fund gratuity as would be advisable under the
He
rules.
would have been entitled to gratuity otherwise. Even if he was not entitled to pension, dismissal, he was not entitled to gratuity.
Dismissal, he is not entitled to anything. In case of dismissal.
Specific finding.
The gratuity is entitled, we are giving him gratuity.
Right.
Page 85, my lord, we have already sanctioned the gratuity. Now only the challenge is in respect of the pensionable salary. Gratuity we are giving, my lord. Hello.
You did not give granting gratuity. You did not give him anything.
Yes, because
Right.
it was subsequently.
So there was no order forbidding gratuity.
Yes.
Authority. Right, that was not an issue before the entitled to giving gratuity. That the division bench order. Dismiss some benefit from the given. Perhaps understood 23 as a pensionable. But that has to be cleared by the council.
Yes, my lord. Now, my lord,
Now, if it was not cleared, you are entitled to clear it now.
But we will clear it.
No, not in this proceeding. You have to apply this order. Take this order. You find the tenor
sympathetic. I followed because my lord, what had happened that time the question was not with regard to pensionable salary. Yeah, but, yeah. See that. My lord, it is at page 81. Please. My lord, that was not the issue at all. It's not a question. You're not fighting me. You're fighting the issue. The issue will have to be framed. This is the matter where a person attention. The council clarify that there is a distinction between pensionable service and regular service. Service does not necessarily at least function that while deciding this, must have to see whether he instead of leaving it to the authority to decide, how can the authority interpret that reflected in the law? So what by council, absolutely they were heard. They had a program, they had a assistant general manager. Perhaps we would like to ask him, Mr. Saibullah, why no clarification in the application? Pensionable service and service under yet not considered to be issued because nobody raised it. Understand? I follow. The effect only, but committed by your clients. Under legal advice, we don't know. That case, I need to find out what they have done. Yes. This is the order. What they have done is reflected in the issue order. What I could understand, Malak, was that they had challenged the award. So eventually, would say, no, please modify the award and pass a paper. Now they are satisfied with that order and they file an application, whatever money is there, please give it to us. And then we say under Rule 22, you are not entitled for pensionable. It's not covered by the order of the pilot. Not just once, there are 2-3 references in various paragraphs where it says 23 years of service. So perhaps the division bench was swayed by the fact that he put 23 years of service. He is defaulted in respect of what loan taken on his behalf, nothing to do causing loss to the bank. He is an ailing mother. All these things were playing in the mind of the court. Nobody thought it. Obviously, the petitioner did not think it necessary to correct it. But it was in the bank. Started bringing to the notice. That was not done. That is so. But one thing is there, Manoj, from their own meeting, it's absolutely clear that they have completed around 15 years of service. So, but that again a finding that is again confirmed that 23 years. That is correct. If nobody made an attempt to correct it. What orders are wrong. Come back and get it corrected. You are as an officer of the court, you are aware how the orders are. that eventuality is connecting instruction to the client if you want to.
Yes, you have to get your instruction and you have to, you have to standing.
At the 10th final.
Also point out that for a division bench, no such distinction was made regarding service.
That's what
bench.
we have already said.
Yes, and secondly, the division bench gave an opportunity that you please produce the service record, so that the division bench could see whether 23 years was completed or not. That service record also never came. And
That is correct.
even in these proceedings, service records have been called on to 3 occasions.
My lord, what we have got, I have got a copy, my lord. Last date I aggregated. I got a copy.
He's given me a copy, only 2 pages of
Yes,
attendance
because in this book, only 2 pages are filled up. I have informed my other. Best our limit.
attendance register.
Because
Also of the period.
showing the service book if you have.
I have shown it.
No, he's given me a copy. It has 2 pages of my leave register of the year 2001.
Thereafter, no, after 2003. Thereafter, he was absent. Unauthorized.
But while the division bench comes to a conclusion that 23 years was completed, that was the thrust based on which a finding was given that the punishment is too much. Today, my lord, the division bench order has attained finality. My length of service cannot be revisited. The remedy, they also had a remedy to go in.
Erroneous on the part of the court to say that it can never be. Can it from facts? Correct.
But as the records stand today, my lords, it has attained finality.
But it was incumbent part of the respondents.
Correct. And it's the judgment of 2022. Judgment of division bench of 2022.
Matter we have done. We'll take instructions and then we'll come up.
Dismissal. Considering the facts. Circumstances. Another order. Finding to have been on. The review order to say that the petitioner is vital. Book. That's the reports.
One, madam.
Orders, pass orders of service. Superannuation bill. Considered for necessary, equipped by the 20 years of pension concern. However, the one of the writing of the the attempt made by the reports. Enabling test again after 3 weeks. I don't, but it's very to petition.
We have already served them a copy of this. served a copy of this. We have already served them.
As for the last of the council for the
Grateful.
Some typing. And second, in the that appointment at the point. Therefore, was the file a petition. The pendency of the petition was on the record. They did not police the record. And ultimately, they were compelled to the appointment.
any order passed by the court.
Kindly. Page 33. There are several orders lodged from place in all orders by passed by the court. Therefore, they could not police. Page 32 order. After the 32 order lodges, they give an undertaking before the court that they are going to consider the case. I was denied appointment at the right time also.
There are finding by the court that your denial. Is there any finding that
Earlier, my prayer was for appointment.
prayer was for appointment, come up with for
Yeah,
33.
and I silenced the appointment of the
Correct. What happened in the petition?
petition losses, finally losses. After the appointment order, that was losses, closed loss. Page 35.
35.
Page 36.
There is no finding that you were wrongfully not given appointment.
So, in the pendency of this petition, the court
See, page number 33. And finding that finding
the court page 34. Content.
that was an alternative prayer. The prayer in the inside their appointment.
The thing is that the appointment and also for Mandamas to appointment.
Appoint you.
There is an alternative.
Decided to grant you your alternative. Then can be appointed. Finally, you are only appointed. Prior to this. Then your claim would finding. There here.
Yes, it's over. Director of Social Welfare. There is an exactly identical case of decided by the Honorable Court. And case number versus 54. Case number 45. 44. And case 46. Ask from second paragraph. I hope the only
46. 46. 46 is post title.
What are the cases? 2916 of
916. 46.
case 40, using 45 also.
Paragraph
Because last before the second paragraph.
in page number. Six is the post title of Mazunwara.
First part of the judgment.
That's all.
Last part of the judgment.
First.
Last part. Paragraph during the course of the hearing.
You have the error.
In view of the above, yes. This is page number 51 in our petition.
That remains for determination is as to whether the appointments of the petitioner should get back to the interior. As noted above, the selection was conducted in 2005 and appointment had been made in November 2005 and
But
February.
that finding is not there. That's what we are telling you. You're appointed in terms of the order.
No, in this case also, within the pendency lawsuit, the petitioner was.
This paragraph, finding by the court that your appointment earlier date finding like that. Finding is that there is an alternative prayer for the appointment. Private. Finding that you have been appointed as an there is the affidavit where such averments are made by the respondent that there was some defect.
India affidavit lawsuit, they have stated that lawsuit in paragraph. They have cited one case of.
So give us your paragraph number.
Paragraph number is 46. Paragraph number 4 was it? This is the continuation of the paragraph number 4 at page number 50. Was it? Here we have given one example of the case also of filed by Srimati Suborna Lata Das versus Supervisor ICDS Kote Nagaon, petition number 9006-2016. What we have mentioned here is that the government is social welfare department
This affidavit is filed by who?
filed by Lordship respondent
Satyajyoti Barua.
respondent number 2 Lordship since the
Satyajyoti Barua.
additional director of the Omnibus.
There is no name.
Satyajyoti Barua, yes sir.
Then para 4 is something else.
Para. The continuation of para 4. The para 4 is Lordship 1 is the para 4 is itself is a 4-page para.
Whatever it may be, you are reading from which part?
I'm reading from Lordship in continuation page number 52 Lordship.
Yes.
In the second in page number 52 second paragraph. The deponent further states that another matter relating to national benefit in respect of Srimati Suborna Lata Das, Supervisor Roha, ICDS Project Nagaon against writ petition 9006 public 2019. The government in social welfare department has informed her letter number so dated 17/6/20 view of judicial department. It is a settled law that a person cannot be allowed to draw the benefit of a post, the duties of which he has not discharged. Srimati Suborna Lata Das, Supervisor Regular Raha, ICDS Project Nagaon,
was appointed based on the order of the Honorable Gauhati High Court. Therefore, as per the view of the Judicial Department, the question of granting her seniority in before her appointment and giving him other benefits of service does not arise. In view of the views of the Judicial Department in matter relating to personal benefit in respect of Srimati Subarnalata Das, Supervisor Raha, ICDS Project Nagaon, against petition so the claim of the petitioner would not be allowed as the matter.
That is in respect of some of the case.
Basically, giving,
Is there any finding?
there is no specific finding, but what they are trying to say.
You are giving this order in deference to the orders passed by the court. Really?
They are basically trying to trace the facts of the Subarnalata Das. Particularly in this case.
You cannot draw an analogy that
That is true. So it is just to make our own opinion.
and you are asking for security. Otherwise, understand something, is there a finding by the court that related? That identification from the prayer, it doesn't appear to be. Prayer is very specific.
Benefit
you are asking for notional benefit. And rest for the finding by the court that no finding is necessary. Other prayers are there. So I'm praying for taxation of fees on a different ground. That's to answer the query. Where is the finding? Writing us to find, we'll keep it for some other day. Come after the hearing. Not for admit. Parties. Since pleadings are complete, we should matter step over. Step. We propose for case law.
But some time we have received instruction as well as the
Yes. See list again after 4 weeks. That's the list.
Right.
File affidavit. 43 respondents are to file. 44 also, my lord,
What is the prayer here?
prayer here means, my lord, the discipline proceeding was broke. So that we have challenged, my lord. And
Proceedings completed.
not yet completed. Because in for the item number 43, my lord, the court's order is there that I have been allowed to file WS, but during that the 1 week time has been given to file WS. Meanwhile, my lord, on the day of hearing, all the inquiry report was prepared. So I have approved this, my lord, and that has been stayed, my inquiry report not to be acted upon, my. So, my lord, there the third case that an letter has been issued by the deputy additional deputy commissioner from Qatar Silchar.
So in WPC 7545.
WPA 7545, they have filed the respondent cooperation department has filed affidavit. Prayer also held, so I have challenged the disciplinary proceeding because anomalies are there.
Wait.
My lord,
You go and file an appeal.
my lord, so
Statutory appellate authority is there. File an appeal.
what I have projected, my lord, here, my lord. Letter has been issued by the deputy commissioner respect of misappropriation money by the secretary of property society. He is a departmental officer, man. So that process, whatever the process was initiated by the deputy commissioner itself, and he has processed the matter and he has distributed the money in civil supply department in judgment. So now subsequently this letter has been issued. On the basis of that letter, my lord, the civil proceeding has been said. So my projection is that 44. I don't know.
These are matters of fact which can be looked into by the authority.
My lord.
Why
Yes,
don't
sir,
you
my lord.
file an appeal?
If the my lord, that item number 44, my lord, if that letter goes, my lord,
What is
everything will go, my lord. Everything will go, my lord. Yes. Your lordship will find. This letter I have challenged. That is page 33, annexure 6. So, no, sorry. Page 62, annexure 15, man. Whatever my lord, accounts they have shown already has been processed by the deputy commissioner.
62 is a letter to the deputy commissioner.
Yes, my lord. Yes, my lord. On this basis, my lord. On this basis, the fund has been distributed by the department itself, not by me. As per fund sanctioned by the deputy commissioner, then, my lord, it was given gone to the particular account also, my lord. Then, on the basis of this, they are again reinitiated, my lord. By this letter, the thing has been reinitiated, my lord, and disciplinary proceeding has been drawn. So, I have challenged this letter, my lord. If this letter goes, my lord, everything will go.
So this letter will also require a lot of finding on fact.
Yes, my lord. That's why. So, yes, my lord. If my lord, if I, my lord, if your lordship consider the facts, my lord, today, my lord, or any day, my lord, then
We consider, we are asking you, why do you want us to consider in the face of a statutory appellate authority being available?
Here, my lord, this letter, my lord, it is a.
This is nothing but a report on the inquiry.
Yes, my lord. Report behind my back, my lord. Behind my back. If this goes, my everything will go.
This is a preliminary report.
Yes,
You are not required to be given a copy.
No, because copy has been given in the departmental proceeding. So I found that these very facts, whatever the facts are there, everything has been processed by the deputy commissioner himself. Again, how it has been questioned by the additional deputy commissioner? That is the thing. How it can be questioned?
So where is the order of the deputy commissioner?
Yes, my lord, your lordship. This is my lord, this letter has been issued by the additional deputy commissioner.
Now,
And
what is
yes,
the reply of the DC?
Yes, my lord. Now, your lordship will then, your lordship will kindly come into the page.
My lord, Annexure 8, page 41. Whatever the funds are required, I have been re-deputed in that office, my lord, as the secretary by letter dated Annexure 7, page 40. That may kindly be seen. Annexure 7, page 40. In the interest of public service, the other junior inspector of so and so, so and so, so and so is hereby allowed to take over charges of secretary of Gumrah Corporation Society, so and so, so and so. And subsequently, my lord, the letter is of 11th May 2018 has been issued to me, my lord. This sanction has been given by the deputy commissioner.
Additional
But the copy has been served to the. He is injured.
What is the stand of the respondent?
That is the thing. That is the thing. They are to respond, man.
They have not filed.
No,
Why have you not
they
filed?
did not file anything. They were given time to file affidavit. If these things does not come, then my lord.
Then civil supplies in DC. Mr. Dhor,
Earlier, Jay Goswami had appeared. Then M. Bhattarji also appeared.
what was the response of the DC?
Yes, my lord. He is the in charge. He has distributed the everything, not by me, my lord. So, my lord, if it is questioned again by subsequent additional deputy.
You have not understood the query I
Yes,
made.
I
You have understood,
yes,
but you don't want to reply.
my lord. Deputy commissioner did not.
Did not reply. That is what.
No,
So
here-
he did not reply.
No, deputy, what has happened? Register of Cooperative Societies has issued a letter, my lord, to the deputy commissioner. That your lordship will, if that letter itself shows, my lord, that 62, page 62, that report, whatever. The report says, my lord, that this thing has gone behind my back.
62 is the additional DC.
No, my lord. This is the
Additional DC. 62.
yes, my lord. You kindly look at my lord. Two deputy commissioner Kasal Silcha. The reference is letter number so and so from the Register of Cooperative Society.
Where is that letter?
That reference.
So where is that letter? 3rd of January.
That letter, I don't have that letter.
Don't have.
No, I don't have. But then subsequently, my lord,
The register must have asked the additional deputy commissioner to make some inquiry.
yes, my lord. Whatever the inquiry they have made, my lord, from assistant registrar of corporate, they have already earlier they have issued, my lord, they have allowed me to distribute the amount. So behind my back, this thing is so much. That's why, my lord, if this letter goes, of this letter is examined by this honorable court, then everything will go. Discipline will not be initiated. That's why, my lord, they have to reply, my lord. Because whatever the money sanction,
Who is the appellate authority in respect of discipline?
government cooperative department.
Corporation department.
Now, my lord, I
So
have
instead of us calling for the record from the corporation department, the corporation department call for no record to examine whether the basis of the inquiry is.
that will also it will be disposed of. My lord. That was also in that manner also my appeal. I may be allowed to file appeal then. Government might not have.
Who is the appellate authority? Principal secretary. What about DC? Have that letter at January.
Therefore, my affidavit from them is required.
3rd January 23, Registrar of Cooperative Society. Give us those excuses. If you are not ready, you should have prayed for time. Once you appear, you are expected to be ready with the brief. Heard counsel for parties, the By whom? Who has initiated disciplinary proceedings?
Sir, Commissioner.
Registrar of Corporation. Query made by
Kachar.
and which 75, 45. Where are the pleadings completed?
75, 45, it is complete.
75, 45 pleadings are completed. Registrar of Corporation. Department will obtain instructions and place by the Registrar of Property Design. Respectively. Seventh of state responsibility will endeavor. Affidavit file.
Yes, we file. We file.
Mediation fail. Mediation fail.
Cannot be money.
What is this?
They are seeking, my lord, pension, work charge employee. We will file a reply.
File a reply. Counsel for the petitioner submits that it's time to file the reply. There may be instructed 2 weeks on a date to be fixed by the registry. So there are no Mr. Mehdi for Accountant General. Accountant General. You are asking for what?
Family.
Family pension. These matters are covered by judgments of the High Court. Right?
After there another judgment. After another judgment. There are nothing going against it.
Like to 6. Accommodation for 3 minutes.
Sign. They will say in the
The date
16th March.
March 2nd.
pertains to non-payment of the repayment benefit. File the
File our affidavit, my lord, and already we have done our part, my lord.
You want to file a reply or something?
no requirement.
Not required.
Only
Great.
the annex, all the documents.
CRG, my lord, GIS and unutilized leave, my lord. Everything has been sanctioned, my lord. It's up to the finance and accountant general to.
So the finance and accounting in. You are for the? Please get instructions on the audits past available at page 53. Do you have a copy of the affidavit? Please furnish adequate copy. See? CRD.
CRG amounting to rupees 24,880.
CRD. Salary.
Leave salary and GIS.
And GIS. Sanction.
One.
Finance department. Status of the as sanctioned by the BTC department. It's again after 2 weeks.
That sanction letter was sent on 6th of December 2024.
There we have seen.
Any date.
16th March.
Earlier date.
Earlier date. 13th. Counsel for parties in issues raised in the writ petition stands covered by and since the parties agree that it's then covered by the stands allowed terms of
181, madam. 181, 82.
service with continuity of service for all. Seniority and pensionary benefits as well. They shall not be entitled to equities for extends. But it is to be given effect to after 8 weeks. 8 weeks is not passed. 31, 86. Have you filed any appeal? This order passed today shall be given effective on the same day. Order passed on the date of appeal, directed to
Lordship, at the time, small handle, if the petitioners are covered, Lordship, a small handle of verification may be.
verify and pass.
Covered.
Yes, okay. Otherwise found to be covered, similarly placed, covered by the judgment of. But the problem is that we have to interfere with the termination orders.
Yes, Lord.
Then what you're supposed to verify and tell us that it is covered or not covered.
Lordship. I mean, almost over, madam. Some other day, madam.
Counsel for the petitioner submits
If you order is just-
state after 2 weeks. 23rd March. MS Bora and
Interim order is done.
Huh?
Interim order is
Interim order passed